Good morning, all. We're here for the appeal hearing in the matter CA5, 2017, before Chief Justice Michael Hwang, Justice Jeremey Cooke, and Justice Zaki Azmi. The appellant is represented by Emirates Legal. Lead counsel is Sayed Mujtaba Hussain. The respondent is represented by Global Advocacy and Legal Counsel. Lead counsel is Michael Paget-Joyce.
And I do have co-counsel, Ms. Lacken, who is sitting immediately on my right.
And Mr. Hosam, you also have co-counsel?
I don't have a co-counsel, but I have my two legal associates assisting me.
Fine. Let's try and get this through, this case through by the early afternoon. So I would suggest, if you can, ideally if you could finish the first round of submissions by the end of the morning. So, roughly aim at something like 1 hour, a bit less than 1.5 hours each, so that we can finish by 1. And then we'll come back and see where we are and have another short round of rebuttals, if we can do it. Let's see how we go.
Your Honours, with your permission, I'm representing the claimant, the defendant in the instant proceedings. I'm the appellant here. For the purposes of convenience, I might use the term appellant and defendant interchangeably. The reference would mean to the same thing.
Maybe it's easier if you say the buyer and the seller, then we don't get confused. Yeah. Let me do it that way.
I will try my best to.
Yeah, I know you mentally have adjusted to one or the other.
Well, I represent the buyer. And the issue, for the housekeeping purposes, if I may take a minute or two to explain my hearing, there are 4 bundles. Bundle 1, which is the document that contains the judgment and some other authorities. Bundle 2, which contains the documents filed by the buyer. And bundle 3, which contains the documents filed by the seller. And yesterday we circulated, for the purpose of convenience, we circulated bundle 4, which contains the kind of the chronology of the documents. And I would like to point out that my learned counsel has prepared, yesterday he circulated a skeleton arguments, not that which he had circulated earlier, but he provided the cross references, copy of which has also been provided to the court. Is there anything else you want to add, sir?
I'm very much obliged to learned friend for introducing matters in that way. And he is absolutely right. He provided the cross-referenced skeleton and chronology in soft copy form yesterday. And I had hard copies available for each member of the court. And the learned friend has hard copies as well. So, with your permissions, I'll hand those matters in. Thank you.
So the manner in which, Your Honours, I will proceed is as follows. Instead of reading out the chronology and giving you the pattern, I would rather take you through the documents in a chronological order, because it's absolutely critical to bring to the attention of the court in this re-hearing of this matter facts and issues that were presented before the court but were not adjudicated, but were not decided. So kindly bear with me, and I will try my best to cover the issues as quickly as I can. And to begin with, I want to make 6 critical observations of the judgment, and I will only at this time indicate those points to you. So initially I will juggle with bundle 2 and bundle 1. So if you have bundle 2 and bundle 1 in front of you, that will be absolutely helpful. So may I invite you to look at bundle 1 first. And I'm looking at tab 2, page 24, running page 24 at the bottom. If Your Honours have it.
There are two figures, one in circle. You are referring to the one in circle?
The one in circle, Your Honour. The one in the circle is what I would be referring to in my submissions. That is the running page number, Your Honor. With your permission, this is the impugned judgment and paragraph 86 of this judgment, which I'm going to read to you. Thus, pursuant to Articles 86 and 87, and we're referring to DIFC contract law, the claimant validly terminated the contracts on 8th of July as a result of the defendant's fundamental non-performance. The point is, regardless of whether such non-performance was of his own act or omission. This is the point that I want this Honourable Court to note. And then I invite this Honourable Court to paragraph 85, which is just one page before. At paragraph 85 of the same judgment, I would like you to save time, I would like you to move to the next page where it's where the paragraph 85 is about to end, and the last 5 lines read as follows. While I make no comment at this time as to whether the claimant has properly exercised any right under Article 6 of the contracts, the 8 July termination letter acts as a valid notice of termination under Article 87. It was sent promptly. Honourable Court may note the point. It was sent promptly and it was admittedly received. So there are 2 observations with regard to this paragraph, which is that the court did not find the need to make any comment with regard to whether the right was properly exercised. And at this stage, the Honourable Court may note that the claimant says that it terminated the contract on the basis of Article 6. If the contract was terminated on the basis of Article 6 or Clause 6, it was important that the court should have disposed of this matter looking at the true interpretation of Clause 6, which was not done. I now invite this Honourable Court to the running page 21, which is paragraph 80 of the judgment. At paragraph 80, if you have it in front of you, Your Honours, it is at page 21, running page, in the circle. It says, given the applicability of the DIFC contract law, and given that the claimant seeks only a declaration that the contracts were terminated, either on 8 July or now, I find it unnecessary to resolve the parties' disagreement on the interpretation of Clause 6. Instead, I find that the contracts were terminated on 8 July 2015 pursuant to, and the Honourable Court refers to the Articles 77, 80, 81, so and so of the DIFC contract law. Moving further, attention is invited to paragraph 81 of the judgment, which is running page 22. And it says, I will read the 3rd line of this paragraph. I find that the defendant's failure to make the payment by the extended due date of 18th June 2015. So the point to be noted is that 18th June 2015 was the date, extended date, to which they had agreed. And it says that it qualifies as non-performance under the DIFC contract law, and then the words are, regardless of the reason for this failure to perform. The defendant argues that mere non-performance without fault on part of the defendant does not amount to a breach within the meaning of DIFC contract law. However, the DIFC contract law is written in terms of non-performance rather than breach. I think this clause itself raises a few important questions that must be answered, which I will elaborate in my submission when I come to Clause 6. But I want to point out 2 things. Just we saw in the earlier observation, the court said, I am satisfied that this contract was terminated promptly. The word promptly was used. I understand the word promptly. Reference means immediately thereafter. And the point that I would like to bring to the attention of the court later is if 18th June was the deadline, if 18th June was the cut-off date, if beyond 18th June nothing should be looked at, why is it that they waited until 8th of July to terminate the contract? If time is of the essence, and if the parties intended the time to be of the essence, then would the time of the essence be automatically extended until the 8th of July? And this is the point that I will answer in my submissions. I want to take your honors to the last two observations from this judgment. Paragraph 89, which is at page 20, is again a very relevant observation by this honorable court. At paragraph 89 of the judgment, it is stated that, therefore, and it is the bottom line, complete at the bottom of the page, therefore, regardless, once again, the questions are, regardless of whether the acts of the bank amounted to force majeure, regardless of whether the defendant's failure to pay was due to his own act or omission, and regardless of the proper interpretation, which means an interpretation of Clause 6 was required, and regardless of the proper interpretation of Clause 6 of the contracts, the claimant was entitled to terminate the contracts pursuant to the DIFC contract law and did so accordingly. Your Honors, last observation is at page 20 again, paragraph 71 of the judgment, which is Your Honors, I found it, paragraph 71. Whether the defendant made the best efforts to complete payment, whether the claimant prevented payment after 18th of June, or whether the claimant wrongfully deposited the security check, are not relevant to the dispute at hand. Your Honors, with these 6, there are other things I have mentioned in my appeal notice which I don't want to repeat at this stage, but I want to bring out only the crucial and the critical observations that I feel are extremely critical in understanding the case. If we were to analyze these 6 propositions together and summarize them in one paragraph, that paragraph would read as follows. The court is of the opinion that 18th July was the cut-off date. Court believes that
June, you mean? Do you mean June?
18th of June, I stand corrected. 18th of June is the cut-off date, 2015 is the cut-off date. The court believes that 7th of July 2015, the date of termination notice, was served promptly, and court believes that while there might be circumstances, while I may have made the efforts to make the payment, but unfortunately, they're not going to look beyond this cut-off date because time is of the essence. In other words, this whole case boils down to the cut-off date of 8th of July 2015, and anything that happens subsequently is not relevant at all. Now I want you to go back for a minute once again to the impugned judgment at paragraph 69, which is at page 10. This is very important. I want to bring out one important fact from reading this paragraph, with your permission. The relevant facts as detailed in the section entitled Background and Procedural History above are agreed by the parties.
Again, sorry, I beg your pardon. What page are you referring to?
Page 19. I apologize.
19. Okay.
Well, paragraph 69.
Okay, thank you. Sorry.
Your Honor. The relevant facts as detailed in the section entitled Background and Procedural History above are all agreed by the parties in their submissions except for the defendant's claim that his request for an extension of time detailed in his letter of 12 July was granted. See defendant's skeleton arguments, so and so. However, the defendant provides no evidence that this extension was mutually agreed between the parties, and thus the discrepancy is a minor one that can easily be dismissed as per the claimant's letters of 8 July, 11th August, 25th August, and 26th August, dealing with the contracts would be terminated, would be treated as terminated by the claimant. No extension beyond 18th June was explicitly granted. Now, Your Honours, so the case is very clear that we failed to provide the evidence that there was an extension in this regard. We did not provide any explicit evidence. And that brings our inquiry, unfortunately, to kind of looking at the evidence that is on record to demonstrate what actually happened. And this is how I'm going to take you through the chronology. Rather than reading out to you my submissions, I want to go through the exact documents that we need to look at. So I'm going to approach this subject in two ways. There's only one way to do it. What happened prior to 8th of July and what happened immediately after 8th of July. And it is in this context, it may appear, it may take a little about 25 to 30 minutes, may sound like a little boring, but this is the crux of my case because I want to present this evidence. I want to be satisfied that I have brought this attention to the attention of the Honourable Court. Now, at this stage, may I request Your Honours to take note of Bundle 2. And if I would request you to open, this is tab 8. Bundle 2, tab 8, is the first witness statement of my client, Mohammad Akbar Zia, the buyer. And may I take you straight away to running page 107 in the circle. The page begins with paragraph 11.
Yes, what?
Your Honours. At the request of the claimant, upon signing the contracts, I handed over a security check to the claimant for an amount of 10,512,960, which was calculated as 10% of the total purchase price as security deposit. This security check was presented to blue chip real estate brokers who had brokered this transaction and was to be returned to me upon the issuance of SPLC in favor of the claimant. Paragraph 12. Pursuant to Article 3B of the contracts, I agreed to make the payment of the purchase price by issuing an irrevocable let SPLC, valid for a period of 1 year, which is considered one of the most secure methods of transfer of funds by the bankers, as Stranger Investment Bank, to be advised by Mashriq Bank in the name of the claimant for a cumulative purchase price of 805 million.
Let me just stop you there. What is meant by to be advised by Mashriq Bank?
Mashriq Bank is the correspondent bank. When we open a standby letter of credit, because my client has an account in a bank in a stranger, now when they open this letter of credit, we send a letter to, in fact I have the whole procedure here, we send a letter to the opposite, to the bank asking them to issue an SPLC. The bank has to be, satisfied. The bank has to be satisfied that I have sufficient funds in my account.
Which bank?
The bank is a stranger bank. So that bank is the bank in which I have the account, which is outside of UAE. That bank will then, upon my request, issue send a swift message to a bank in the UAE with whom it has a relationship. Here, the Mashriq Bank is the correspondent bank that will receive those instructions. And Mashriq Bank, when it receives those instructions and it's confirmed that they have the money, they will then transmit the funds that are received there into the account of the DIFC. Now, there are two things that happen in the process. First is there are two messages that go. One is MT799. Now, what is this MT799? It's simply a free format Swift message type in which the bank confirms that the funds are in place to cover the trade. So the bank has to send this message to the Mashriq Bank, which is the correspondent bank, that we have the funds, I confirm that the funds are in place to cover the trade. And second is MT760, which is that the issuing bank puts on hold on client funds, blocking the clients from using them. So which means what happens is when an SBLC is open, my account, my funds in that bank are blocked. That amount which I have used is completely blocked. And the funds are then at the disposal of the beneficiary through this process. So the beneficiary then has to go to the correspondent, will show the documents to the correspondent bank. The correspondent bank shall then remit the funds to the account. So Your Honor, since this issue was raised, I want to come to one more connected issue here, which goes down to the root of this matter, Your Honor. The method of payment normally, Your Honor, is not a standby letter of credit. The method of payment is generally you open a manager's check and make the payment through a bank account, you transfer the funds directly into the account. In this particular case, Your Honors would appreciate that it was in the contract, it was agreed, because our client did not have this much of funds in this country, so it was agreed that standby letter of credit would be an option. Now, standby letter of credit has a very unique, interesting way, the way this moves forward. Once they send an instrument they send a message to the Mashriq Bank. Mashriq Bank looks at the standby letter of credit, and Mashriq Bank must approve the terms which are there. So there's a possibility, howsoever remote it may be, that Mashriq Bank may possibly or could have rejected or could have said that there is some variance which we do not agree in your standby letter of credit issued by the foreign bank, so we want it to be amended, or at best Mashriq Bank will say we will not process it. So if time was of the essence, so what was required on part of the opposite party? What was required on part of the seller is to seek a pre-approval, as is the general practice, of these terms of the SBLC, approach them and say that yes, this is approved, and you proceed. But this didn't unfortunately happen. If you see from the pleadings of the parties, there is nothing that the seller has written in their submissions which say that we sought a pre-approval. What I'm trying to say is that there is an assumption of risk. There's an assumption that there may be a possible delay if the wording was not approved. Unfortunately, in this case, something different happened. Unfortunately, in this case, the SBLC was dishonored, was not honored by Mashriq Bank. And the reasons that were given where it was not honored because we believe that there were proceedings against my client or some Interpol notice has been issued, and for the compliance reason, this was, they refused to honor it. Now the issue here, Your Honor, is how did we come to know that there was Interpol proceeding against my client? The question, I interviewed my client and I asked this question. I said, sir, were you aware before you opened a standby letter of credit? Were you aware of this Interpol notice? Because if you were aware, unfortunately, you have no case. I was told by my client that he only came to know about this when the Mashriq Bank raised this objection. Now, Mashriq...
When was that?
It was in the proceedings. What had happened is, the seller initiated, when they deposited the security check and the security check was not honored, they initiated criminal proceedings in the Dubai courts. And at that stage, one of the gentlemen from the Mashriq Bank, a senior person from the Mashriq Bank, was cross-examined, made a deposition before the court in which he said that I have reason to believe that there are Interpol proceedings against my client, and hence there are compliance issues, and hence we were not able to honor it. This is a very critical point. Unfortunately, I don't want to talk about Part 8 at all, but my understanding of Part 8 in the hearing was that I wanted an opportunity to cross-examine this person and ask this person these questions, what points he has to show to demonstrate that it was because only of this reason. Now, why we are talking about this is simply because once the money leaves my account, as Your Honor asked me this question, and I open an SBLC, my money is blocked, so I cannot use this money at all. Now, the issue is the money has not been credited into the account of the opposite party, of the seller. I agree, Your Honors, that money was not credited because Mashriq Bank did not honor it. But Your Honor, just now I'm going to demonstrate to you with evidence on record, admitted evidence, that when I use the words, I did what I can, rather than using those terms, I want to show by by evidence on record that my client did everything under the sun to get those things. There are two reasons why he did that, Your Honor.
But that is only mitigating points, but does not go into your performance of your terms of the contract. I mean, mitigating for you, yes, they can sympathize with your client, but still, your client didn't pay the money for whatever reason.
Your Honor, that is the crux of the case, and that is this is the question, Your Honor, which I'm going to address. But the way I'm going to address, I can answer it right away by raising two submissions, which is that my client also paid the terms of the contract, where that my client was supposed to pay for the NOCs from the developer. 108,000 dirhams were paid by my client. My client also paid service charges for Amikul. My client also incurred other costs. I paid the money. I had an interest, Your Honor. I opened an LLC. I paid the money. Money was received. These no objection certificates were handed over to me. I had
no
an
objection
intention
certificates?
to perform the contract.
Sorry, counsel. What are no objection certificates?
Sorry, Your Honor, I didn't get.
What is a no objection certificate?
A no objection certificate is that this is the property which is in Dubai, which is owned by such and such person, and we have no objection of the sale of this property to the concerned person who is the buyer.
Why is it necessary for there to be a no objection certificate? If your client is the owner.
Our client at that stage is a prospective buyer, and in order for him to
what do you mean by a prospective buyer?
A person who has signed a sale and purchase agreement.
Then he's the buyer. He's not a prospective buyer.
Well, the reason I said, because the money had not been credited into their account viewed in that perspective.
That's an uncompleted transaction, but he's the buyer, is he not?
As per the sale
Unless you say that in the contract of sale between the developer and your client, there is a prohibition against sub-sales prior to completion. Is that what you're saying?
No, there was no prohibition at all. But this no objection certificate was a part of the procedure. It was a procedural requirement as per the applicable rules, meaning the property could not have been sold to us without obtaining a no objection certificate. And
because what is the objection or what is the prohibition against your client selling the property without a no objection certificate?
Buying the property, Your Honor.
No, sub-selling it. What your client is doing is sub-selling it to a third party, in other words, their client. What is there that prevents your client from doing so at any time after he has signed the sale and purchase agreement?
The title deed, my title must be registered before I become the owner of this property in the interim register maintained by the Dubai Land Department. So the rights will not transfer to me in respect of the property unless and until that title deed is registered in my name. At this stage of the proceedings, when I signed the sale and purchase agreement, I opened a standby letter of credit. Both parties had to take effective steps in order to register the property, which had not been taken simply because money was not received. And one of the conditions, Your Honor, in the contract, in the sale and purchase agreement is, if the no objection certificate is not granted by the developer, it is written in the contract, if the no objection certificate is not granted by the developer, the claimant, the seller, will return all the earnest money or the deposit or earnest money that I have paid in this regard. So, Your Honor, it is in this regard that my client opened an LLC, blocked his funds, paid the money. If I have your permission, Your Honor, should I go into what the evidence that I want to present before the court, or should I first answer any of your questions?
No, please proceed as you want.
Thank you, Your Honor. I'm much obliged. Now, paragraph 13 on page 107, which you have in front of you, it says the point to be noted here is that SPLC would mature after a period of 1 year from the date of the issue. However, the SPLC was issued in the claimant's name. The claimant could, at its option, discount the SPLC at any time prior to the expiry of SPLC. Pursuant to clause 2 of the contracts, the claimant had undertaken to complete all the proceedings and requirements to transfer the property in the buyer's name immediately after taking possession. Your Honor, a question was raised in the skeleton of the seller that you issued an SPLC which will mature after a period of 1 year. What I will demonstrate to you shortly is that this is an SBLC, which I could have discounted at any time, but all that it would entail is 4.5% of the fee that has to be paid. Now, you will see in our subsequent negotiations, we even went forward and said to the opposite party, to the seller, that look, we are even willing to pay these 4.5% discounting charges. So whatever is stated here, this is the agreement of the parties, Your Honor.
So
now,
it wasn't a letter of credit that could be encashed for its full terms at any time before the expiry of the year, was it?
Yes, it could be
only be
encashed
discounted.
Immediately. It could have been
Could be
encashed.
discounted.
Discounted.
You couldn't encash it for the full sum of money for the purchase price until the expiry of the 1 year, could you?
Well, my understanding, as per, and we sought a confirmation in this regard as well from the client is, as per the documentation available on record, is if all I need to pay is 4.5%.
That's the discount value.
That is the
letter
discount
of
value.
credit.
And rest, whole amount will
Can you
come back
answer
to
the
me.
question? The letter of credit in itself did not enable encashment to take place until the expiry of the 1 year, did it?
Your Honor, let me rephrase my answer, so if I'm able to address your question. When an SBLC was opened it was supposed to be valid for a period of 1 year. The idea is that this is the money that is available to me, who is the beneficiary, that is the seller.
Yes.
Now, I as a seller had initially our understanding was that the seller would pay 4.5%, and Your Honor is right, which means 107,000 minus 4.5%, and you get that value. But we subsequently agreed, and you will see from the evidence on record, that you will receive exact 107,000. We will pay those discounted charges. In other words, you will receive the exact amount for which the SBLC was opened on the very first day that you submit the documents to the bank. In other words, no amount will be withheld. Complete payment as per the SBLC would be received. And I want to bring one more point to your attention, Your Honor. This amount of 107,000 includes the 2% transfer fee, which we were supposed to pay to the Dubai Land Department as well. So it is not just the cost, the consideration of the property, it also includes the transfer fee, which we were supposed to include here. So, Your Honors, if I have answered your question, Your Honor, or is there anything on this issue I need to
I'm just trying to understand paragraph 13.
Yes.
The first line, that the SPLC would mature after a period of 1 year. That's not normally the way that LCs work. LCs are valid for a period, and I thought you said that.
Valid for a period of 1 year.
If you are discounting something, then it is not valid until after 1 year passes. So what are you saying in paragraph 13, line 1?
Paragraph 13, this is the witness statement of my client.
Yes, what is he saying?
My client is saying that I issued an SPLC, which is valid for a period of 1 year.
But it could have been encashed immediately.
It could have been encashed immediately.
So it is not. It doesn't mature after 1 year. It's valid immediately.
It is valid immediately.
Until 1 year expires.
But it expires after 1 year.
Exactly.
It expires after 1 year.
So the discounting is neither here nor there, is it?
Well, the idea is that once it is issued, it is valid for a period of 1 year. So beneficiary has the option to take the money at any time during the validity of this.
Yeah, for the full
SPLC.
value of the LC?
For the full value.
Yeah.
So
Why does a discount enter into this?
Because at the end, the SBLC is valid for a period of 1 year. So if we discount it, as far as I understand, Your Honor, what I just said yes to you, I want to take one step back to that. The SBLC will mature after a period of 1 year, which means the exact amount of this SBLC, as per my client, I will go by what my client has stated here, is that will be valid after 1 year. The issue of discounting comes if we take this money before its maturity, before a date of its maturity.
Can we have a look
so
at
let's
that?
say the date
Can
of
we have a look at the SPLC?
Yes, we can go into the SBLC, which is.
Are you saying that if you present the SPLC before 1 year,
Your Honor's bundle 4? Tab 6.
Tab 6. Yeah.
Unfortunately, this is not the best.
There is a better copy, I think, in bundle 2, behind tab 9 at page 1 3, 4.
Thank you.
Now,
There's a handwritten amendment. I don't know whether that's part of the original.
it is part of the,
Of the original.
because some changes were made, Your Honor, to this SBLC.
The original is as it stands, and that was a suggested amendment that came from one of the banks. So it originally required a promise to pay at expiry date of June the 3rd, 2016, which is why it needed to be discounted.
Yeah, so that was
if it was going to be cashable at all beforehand. So the full sum was only payable at expiry,
Yeah.
as originally drafted.
I stand corrected, Your Honor, by the exact point is what Your Honor just mentioned. We had this SBLC. It was valid for a period of 1 year, but it would mature at the end of 1 year. So if we had to encash it immediately, it was possible, subject to 4.5% discounting charges. And that is what we had.
Does that mean the beneficiary would have to go and discount it?
Beneficiary would have to go and discount it and pay 4.5% of the charges. This was our understanding. And subsequently, as you will see from the documents which I will bring to the attention of the court, we agreed to pay even these discounting charges.
Now, while we're looking at this message, this is the message that goes to Mashrek,
That goes to-
asking Mashrek to advise the seller of the standby letter of credit. And Mashrek never did that, did they?
Mashrek felt that there was some compliance issues. They never approached.
So they never advised.
They never advised.
They never advised the seller that there was a standby letter of credit which they had authenticated, which would constitute a payment under the contract of sale, did they?
Well, if you don't mind, Your Honor, I want to take you now through at least some points which this.
Well, I understand that, but the answer to my question is yes, isn't it? Because that's made very clear by a letter that's in your bundle 4 on the September the 6th.
Page 31.
But the short point, just to confirm and get that out of the way, is the document that you first showed us, which is tab 6 of bundle 4, is the final version, and that does say payable at expiry date of June 3rd. Right? So in that sense, then your client's paragraph 13, which I questioned you about, is correct. Right?
Yes, Your Honor.
So we're clear on that. Now, please carry on.
And this letter which Your Honor referred, I was.
I beg your pardon, Judith. The one that appears at page 134 of bundle 2, referred by also, reads on or before. This, as Chief Justice said, there was some correction. Which one are we supposed to read? Are we supposed to read at or on before the?
On before the.
Not at.
Because this was something that was discussed between the parties. They made certain amendments to this SBLC.
So you want to use the one at page 134 of bundle 2?
This amendment was not carried into effect.
If you look at page 133, you can see the request that there should be those changes, which was never done. Is that right?
I see.
It was never carried into effect.
So you should not read once before, you should go without the amendments. You should read it without the amendments.
Yeah.
Right?
The reason why we refer to 134 because the
I know.
council wanted a clear copy.
No, it was only the clarity of the copy,
Okay.
and I fully accept.
Sorry,
it.
I beg your pardon.
No, it's only clarity.
Sorry.
I apologize for the
As
confusion.
unamended. Read it as unamended.
Unamended is in bundle 4.
Yes, okay.
Can I just try and short circuit this a little bit?
Yes, Your Honor.
If you go to your bundle 4 on page 32,
Bundle 4. Yes.
bundle 4 on page 32, tab 13,
Yes, Your Honor.
we find that the Mashrek Bank
Yes.
is saying in terms they've not advised the standby letters of credit to DIFC. they had referred the standby letter of credit back to the issuing bank, Estrategia, due to compliance issues. So at no point has this standby letter of credit, even in the form which was payable at expiry, ever been made available to the seller, has it?
Well, this is as per this letter and as per the agreement. This point, what you're saying, is technically very correct. At no point in time was the DIFC advised, because if you're using the word advised, but were they informed, were they aware that this was there, and were they aware of the discrepancies or the...
You know what the duty of advising bank is.
Absolutely.
The duty of advising bank is to authenticate the letter of credit,
Absolutely.
as given by the issuing bank, to a third party, and if it refuses to do that, it must then tell the person who's requested it that that's what they do, and that's what happened. So the money never becomes available to the seller, does it?
The money never became available to the seller. You're absolutely correct, Your Honor, on this issue. At this stage, the money never became available to the seller. But but this point, Your Honor, reinforces my earlier argument, which I just raised. We agreed in principle between the seller and the buyer that this is the mode of payment. And one of the pitfalls, rather, if I may use that word, of entering into a transaction of this nature is exactly what we have seen in the instant proceedings, that the correspondent bank may not simply validate for any reason. It could be because of language, it could be for anything, but that risk is inherent, which we assumed. So the point I'm trying to argue here...
When you say we,
which the parties, I'm referring, my reference is to the buyer.
We understand that's your position, right?
So in that context, both parties agreed that this would be the mode of payment. We agreed to this, and subsequently...
And what do you rely on for that common agreement of assumption of risk?
The clause 3B, which says this is how the payment will be made as per the sale and purchase agreement.
So because they say we're going to use a SPLC from a foreign bank to be advised by a local bank,
To be advised by a local bank.
It's implied in that term that parties bear the risk that the SPLC will not work in the way it's supposed to work.
It is not, because Your Honor, it's not really a standard method of payment. A standard method of payment in a real
It has
estate
been around
agreement.
for a long, long time.
It has been, but in this particular transaction, the only point I raised this argument was to drive home the point that if time is of the essence, if you argue that time is of the essence, then you could not have, these were the difficulties that you could have possibly encountered, and we did. So time could not have been of the essence in this case, coming back to that cut-off date, and that cut-off date being so sacrosanct that nothing else beyond that could be looked into.
Yeah, I think this is a point we well understand because you've seen it in your, in your submissions, and yeah. So please move on from that.
Your Honor, with your permission, I would like to move through this evidence quickly. And paragraph 14, where I talk about that I paid the NOC charges to the developer.
Come back to the bundle number again.
It is bundle. We are on bundle number 2, bundle 2, tab 8,
Yes.
and running page 108.
Yes, carry on.
Yes, Your Honor. Your Honor, at paragraph 16. Now, paragraph 16, which is on page 108 of this bundle. It says, at this stage on 3rd June, before the agreed date of completion of the transaction, in the interest of good faith, I, through my company, Interglobe Trading, Dubai, issued an irrevocable SBLC in favor of my company, Emirates Moon LLC. This SBLC clearly stated that the purpose of the SBLC was purchase of 72 units in so-and-so. I issued the SBLC in favor of my own company and not in favor of them. And this is one of the points which the Seller's Counsel has raised in his submissions, and he has said that there is a breach because why did you issue an SPLC in your own company's name rather than in the name of the DIFC? And this is the explanation here, because we have agreed in our contract that we will only issue an SPLC to you once we receive the no objection certificates. And those no objection certificates, on 3rd of June when I opened this SPLC, we had not obtained them. We obtained them only on 14th of June. So we transferred this SPLC, I want to clarify here, in the name of my own company, simply because if you read the SPLC, which we just saw, it says this is transferable SPLC, and this fact is even confirmed by the bankers, the Emirates NBD bankers of the seller, that yes, this SPLC is valid and this SPLC is transferable. So this was the reason. The reason I read this paragraph is to rebut the point of my learned counsel, who argued that we committed a breach in this regard. And even if you read the particulars of the claim, one of the points of the breach is we opened an SPLC not in the name of the beneficiary, but in our own name. So this explains that point. At paragraph 18, 2 paragraphs down, once the issuance of this SPLC was communicated to the claimant asked us to make certain amendments to the SPLC. And Your Honor has seen those amendments, and Your Honor asked me this question whether which of those SPLC should be taken into account. And I was in constant touch with the claimant to make the requested changes. The fact that I was asked to make changes to the SPLC clearly shows that claimant had agreed to this arrangement. Therefore, I was very surprised when the claimant said I was in breach of my contract at paragraph 19. And at paragraph 21, now this is where I want you to go through the documents with me. These are a few documents. On 18th June 2015, which is paragraph 21, following the claimant's advice, I sent instructions to the Mashriq Bank to immediately transfer the instruments to the bank account. So I will not take you through this document because we have already covered this point. I issued instructions to Mashriq Bank. Of course, Mashriq Bank did not later honor these instructions for the reasons that we have already discussed. Now, I want Your Honor to move to tab 9. We have to simply navigate a little between tab 8 and tab 9. Tab 9 is the second witness statement of my client, which is in the same hearing bundle, B2. And if you go to the, if you move to the running page 126, Your Honor, if I may read the last, the 3 lines on the top of the paragraph. The claimant shared a copy of the SPLC with their bankers to confirm if this SPLC could be transferred to the claimant. The bankers of the claimant confirmed that SPLC is transferable in nature. Now, this is the point. If you, the bankers have confirmed that this SPLC was transferable, and this is also a document in the file itself. I'll take you to this relevant annexure. This is page 133.
Wait, back, are we?
On the same heading bundle, page 133, running page
33, sorry.
Yeah. Your Honors will note, if you have this annexure, Dear Nadia, this is an email from the bankers, email from of the DIFC. SPLC is transferable. The transferee should be issuing the transfer letter to effect a transfer to avoid a risk for our customers. Slight changes as attached. Suggest to be governed by ISP instead of USB. Regards, Suman. Now, Your Honor, the next point is that, coming back to this paragraph, the bankers of the claimant confirmed that SPLC is transferable accordingly on 13 June as a gesture of good faith. I sent immediately a letter to the Mashriq Bank asking them to transfer.
So which page you read?
I'm on page 126 of my submission. Paragraph 21, page 126.
Sorry, what submission are you talking about?
This is the first, this is the second witness statement of the...
Yeah, sorry, witness statement is different from submission.
Witness statement.
Tab,
I apologize.
tab?
This is tab 9, same tab, we're on tab 9.
No, we left it to look at the letter, you see.
I apologize, Your Honor, that...
So we are tab 9, paragraph?
Tab 9, paragraph 21.
Right. Okay?
So we are reading the last 3 lines of the paragraph.
Yes.
Accordingly, on 13th June 2015, as a gesture of good faith, I immediately sent you a letter to the Mashik Bank asking them to transfer the SBLC in favor of the claimant and provided details of the bank account. This letter, if Your Honor want to see this letter, is in bundle 4, and I will take you to the exact tab.
I'm sorry again. The
Tab-
letter you just read to us is which page, please? The one that you
Yes.
showed us. Just give me the reference again.
I read paragraph 21, which is at page 126
Yes.
of tab.
No.
Nine.
The bankers of the claimant confirm that the SPLC is transferable in nature.
Yes.
Could you just take me to that
Yes,
particular
yes, I
letter?
will take you to that page, Your Honor. This is page 130, running page 133 of the same witness statement.
Okay.
It is titled as Annexure MA and Z 1 on the top. So, with your permission, may I move to the next point, Your Honor? The
Yes.
procedure? Accordingly, on 13th June 2015, as a gesture of good faith, I immediately sent a letter to Mashik Bank asking them to transfer the SBLC in favor of the claimant and provided details of its bank account. So this is the 13th June letter, which is, you have to look to bundle 4, tab 8, page 22. So you look at tab 8. I apologize about the document, which is not really very clear. We have tried to retype some of the documents, but this we haven't. And this is a letter written by my client, and this is written to Mashik Bank. And here he says, I am highly appreciated your excellent services and your continued cooperation. With this, I would like you to transfer the SPLC issued by such and such bank to favor of Emirates Moon so and so, account number so and so. So I request you to transfer this to the following DIFC account. And then the account name is given, the account number is given, the data branch of the DIFC account is given. Please confirm to us as soon as the department concerns take action on the transfer of the SPLC to the DIFC bank account, as they are the beneficiary as per the agreement reached on 25th January 2013 for 72 units of the same. So, Your Honor, this is an important point. I issued instructions to the Mashrik Bank, and I said, I need you to transfer this SPLC immediately. At paragraph 20, now I want to take you back to my to the witness statement, which is tab 9, bundle 2.
It's good, the paragraph.
Yes. Subsequently, on 14th June, the claimant sent a letter. Now, this is important.
For the record, you're reading paragraph 22.
Yes, I'm reading paragraph 22, running page 126. The second witness statement of my client, tab 9. And it says, paragraph 22, reads as follows. Subsequently, on 14th June 2015, the claimant sent a letter agreeing to accept the SBLC issued by my company, provided the SBLC was transferred to the claimant's bank account in Mashrik Bank. Now, I want to take you to this relevant paragraph, this relevant letter. This bundle 4. Tab 9. Page 23. We have retyped this as the print was not clear, and the retyped version is at page 24, with your permission. So this is a letter which has been written to us by Mr. Rajesh Parikh, who is the works for the DIFC. It says acceptance of SBLC in consideration of the above mentioned subject. We DIFC Investments hereby accept and receive the 1-year irrevocable SBLC issued by Estranger Bank to to be advised by Mashreq Bank in the name of DIFC Investments LLC for cumulative total price of so and so and government charges and fees of 82 million totaling 107 million. This SBLC is on account of the transaction entered for the so and so. This SBLC is to be issued on our following bank details, account details, everything is given. So, Your Honor, the point is that at this time, at this stage of the proceedings, the SBLC was accepted, at least in principle, in the form in which it was by the seller. Then, Your Honor, in the same, I want to take you back to my witness statement because I want to read the next paragraph, which is again I'm taking you back to tab 9 of my witness statement, where at paragraph 22, we have seen paragraph 23. I refer to paragraph 24 of the first witness statement, wherein I sought the assistance of the claimant and the bankers of the claimant to accept the RMA request sent by my bankers through my letter dated 7th July 2017. Now, as I did not have an opportunity to share the RMA request, now, Your Honor, what happened is, after this SBLC, this thing did not work with the Mashreq Bank, my client, what he did was, he approached the seller and said, there is one more option left for us, which is your Emirates NBD Bank. Why don't we establish a direct relationship with your Emirates NBD Bank? And for that, we have to open an RMA request, so that the banks can easily correspond with each other with a swift message. So,
which bank and which bank?
This is Emirates NBD Bank. I will take you through the relevant document.
What role do they occupy?
The Emirates NBD Bank is a bank in which the seller had an account. Right. So we asked the seller that, look, let us try and get this SBLC, let the correspondent bank, let your bank be the person with whom we will correspond. We want to transmit these funds directly into this account, and for this purpose, your bank needs to open an RMA request, and there are certain documents that you need to provide to the bank. Now, in this regard, I would like you to go to tab 8, which is the first witness statement of my client, and open page 109, running page 109.
Yes.
Now, Your Honor, these are few letters which are in sequence, which are slightly important. I'm reading paragraph 23, which is on page 109. It says, to my great surprise, I was informed by the claimant that the money had not yet reached the claimant's account, despite all the steps that I took to ensure that the money reaches the claimant account. The claimant does not deny the fact that all necessary steps were taken by me in this regard. Mashreq Bank informed me at the last moment that they could not transfer the money to the claimant's bank account due to some compliance issues. Accordingly, now the time period is important, Your Honor. On 29th June 2015, based on the claimant's request, I suggested that I could send the instrument directly to the Emirates NBD bank account of the claimant. Now I want to invite the attention of this Honorable Court to this letter dated 29th of June 2015. And this is, and we have to again go back to bundle 4 for this letter, tab 12. Page 29, which is not clear, so we have retyped this at page 30. I repeat, the letter is at bundle 4. Running page 29 is the original letter, not clear, and at page 30 is the correct version. This letter, we have written a request to Mr. Rahul Batad by my client, wherein it stated that, dear Mr. Rahul, good day. In continuation of our efforts to conclude the deal, which only remaining issue is to transfer the standby letter of credit, which is in Mashreq Bank since 3rd of June 2015, and which we have been requested the bank to transfer it to the DIFC investments account with the Emirates NBD. And since we didn't get any action from Mashreq Bank till today, we come into a suggestion, which is why we don't send this instrument directly to your account to avoid more delay in the transaction. This is written in English, is not very clear, but what my client intended to convey was that we could as well, the suggestion was, we could as well convey, transmit these funds into your Emirates NBD account. Please advise your opinion on this suggestion in order to proceed to avoid any further delay. Now, once again, back to my tab 8 witness statement. Now, what happens subsequently thereafter is, on 7th of July, which is paragraph 24, on 7th of July 2015, I sought the assistance of the claimant and the bankers of the claimant to accept the RMA request sent by my bankers so that I could transfer the SDLC in the name of the claimant's Emirates NBD account. So here I'm seeking the assistance of the claimant and seeking the assistance of the claimant bankers to open this request so that the money can be transferred. This letter, dated 7 July 2015, is once again at bundle 4, tab 14, page 33. If you want a clear copy of this, we are at tab bundle 4, tab 14, and the clear copy is at the last page of this tab, of this thing, at page 41. Page 41. If your honors have found it.
Page 41?
Page 41, running page 41. Tab 14. And the clear copy which is mentioned on the first page, it has been retyped and
So
pasted
the
at
running
page 41.
page is in the center. Because
Yes,
there are two circles over numbers.
that's correct. In the center with two circles, running page 41. Dear sir, we would like to, this is to DIFC Investments, we would like to thank you for your support on finalizing the transaction of 72 units. We are sorry to inform you that the Mashreq Bank refused to transfer. Therefore, we would like to ask you to help, to ask Emirates NBD to accept RMA request sent by so-and-so. If we can have RMA established between Emirates NBD and Stranger Investments Bank, will help us for resend the transaction for future transactions which you would sell, as the SDLC will come direct to your bank account without any correspondent. Kindly note that we are ready and willing to able to send MT799 followed by MT760 to your account in Emirates NBD Bank once RMA is established. So I was referring to these two terms earlier, that we are going to block this money and confirm that this money is there in the account. Once this RMA is established, please note that we are kindly requesting you to give us more time till RMA is established between your bank and the SDLC. Now the date again, which I am mentioning here, is 7th of July. This is one day before they exercise their right to terminate the agreement. On 7th of July, I'm asking for more time. On 7th of July, I'm requesting them that if you can help me open, I still have an option and I can remit this money without a correspondent bank directly into this account. Please provide these details to the bank. Now, coming back to the next point in the paragraph, so we can go through a little quickly. On 8th of July, which is paragraph 26, I was very surprised to receive a letter from the claimant on 8th of July, the termination letter. Now, this termination letter is at bundle 4 once again, tab 15, page 42. And this is simply a letter where they're saying, we refer to the property sales contract that we signed on 3rd May, which expired on 7th of June, and the subsequent extension to original contract signed on 7th of June, which has now expired on 18th of June. Please note that we have provided you with the NOC from the master developer authorizing the transfer of 72 units in your name. However, you have failed to submit a valid irrevocable standby letter of credit by the agreed date. Accordingly, we now exercise the right as per clause of the contract to terminate the same. Very clear termination letter. Your Honor, at this stage, once again, I would like to reiterate my earlier submission, which is, so the cutoff date is 18th of June. They exercised their right to and the whole judgment of the Court of First Instance is based on time is of the essence. And the right has been, the termination right is exercised on 8th of July, one day after I make this request to them, hold on, and we can transmit the funds in this manner. Now this is the date, this is part A, until the termination. Now I want to show, I won't take you through these things, I have everything in one order. Efforts to resolve. What are the efforts? Because this is very critical. Now in this part of the submission, I'm trying to demonstrate to the court with evidence that what are the efforts that I make? Were my efforts genuine, or was it simply an attempt on my part to gain time? But if that is the reason, if my attempt was to gain time, why would I gain time when I wanted this contract to be specifically performed? I had incurred costs and expenses in respect of NOCs, in respect of other charges that I had paid. It was therefore in my interest that this contract is performed. Now, I invite the attention of the Honourable Court to the second witness statement, tab 9. And these are my efforts. From this moment on, I'm going to refer to 5 documents, and these are my efforts to resolve the matter. And this is at page 126. Running page 126. Tab 9, second witness statement of the buyer. Paragraph 25 reads as follows. For instance, on 12th of July, after meeting the claimant in their offices to discuss the delay in the payment due to Mashred Bank, I sent a letter setting out a plan of action as discussed in our meeting and sought an additional 15-day extension to complete the entire transaction. This action once again established my intention to complete the transaction. Now, why is this important, Your Honor? Why am I referring to this letter? The only reason I'm referring to this 12th July letter is because a question was raised by the Court of First Instance that I did not provide any evidence, that there was no agreement amongst us that this time period was possibly extended or anything in that regard. So I invite your attention to 12th July 2015 letter, which is at the same tab, we don't have to go anywhere else, at page 144 of the submission. This is the letter which has been written to Mr. Saleh Al-Akrabi.
So you're taking us to another page?
Yes, sir. Page 144.
Of?
The same tab, the same submission. Sorry, the same witness statement. Second witness statement.
It's an exhibit, is it?
It is. Running page 144. This letter reads as follows. Dear Mr. Saleh, we thank you for your time on Thursday for meeting. So there was a meeting. The first thing is that there was a meeting that was held. So we are talking of what happened post-termination. We thank you for your time on Thursday for the meeting at your office. In continuation to the meeting and due to the delay of the Mashred Bank during the process of the deal, we'd like to inform you that we are willing and able to conclude the deal on the following terms and conditions. We shall send the SPLC directly to Emirates NBD. The RMA message has been sent and the Emirates NBD is working on it. So that's the point. Emirates NBD is working on it to complete the formalities. The bank was aware. This can be checked by your good selves with Emirates NBD. And with your support, we are sure we can conclude it directly with Emirates NBD. Number 2, upon acceptance of the new terms, we shall establish MT799 immediately, followed by MT760. Upon your acceptance of MT799, the total process can be done within 4 working days, including MT760, upon your acceptance of MT799. We request to meet with you again and negotiate on the SPLC discounting charges, which you shall incur. This was our misunderstanding on the issue and the terms of the MOU form F signed with you. We shall need an additional 15 working days extension, as we shall need to renew. The point is, why are we asking for this extension? The reason why we wanted this extension is because the NOCs that have been granted, Your Honor, have been granted for a limited time period. Now these NOCs have to be renewed. And we wanted this additional 15-day period, hoping that while we will perform all other formalities with the bank, we will at the same time renew these NOCs. And you should also need some time with the bank to discount the SPLCs. So this is what we had a discussion with them in this regard. Once again, it shows my intention referring to the same witness statement, at paragraph 26. This is very important. Upon continuously following with Emirates NBD, following our meeting, I was informed that the reason for delay is that the claimant had not submitted the relevant documentation to Emirates NBD. Now this is important, Your Honor. From my perspective, I started the process. I have approached the Emirates NBD Bank. I have asked you to verify that this is in process. Now you have not submitted the relevant documentation, such as the title deeds and other things of the property to the Emirates NBD, so that the transaction could not go through. Accordingly, on 22nd July, I sent a letter. This letter, dated 22nd of July, is also in the same tab, but running page 146. Same tab, page 146. This letter is very important, Your Honor. I am relying on this letter. 22nd of July, 2015. I address this to the DIFC. I say that dear Mr. Saleh, in continuation to the above mentioned subject and in continuation to our deal, we would like to let you know that we have been trying to transfer the SDLC into your account, but we have not succeeded in it. Following the reason, we have come to know for the reason the SDLC not received. As per Emirates NBD Compliance Department, they haven't received any related documents to this transaction from DIFC for the confirmation to receive the SDLC. The documents were title deeds, sale and purchase agreement. As per our deal, since the initial letter of intent, it is very clearly stated that the payment will be made via standby letter of credit for 1 year. Now it is the responsibility of the DIFC to submit the required documents to Emirates NBD to establish and receive the SDLC. We are ready from our side to send the SDLC, but the DIFC has to complete its formalities with the bank to receive the SDLC. Once the SDLC is issued, we can meet and discuss on the discounting charges. But before we move forward, DIFC should first inform their bank about the SDLC to be received. Since the information has not been sent to your bank, we haven't succeeded in sending the SDLC. In order of this letter, and letter sent earlier dated 8th of July, and in continuation of our telephonic conversation, so look at my efforts. I would like to meet you to conclude the deal at this moment, and all the delay so far has been by the banks, and also since the information to receive the SDLC was not provided to the receiver bank. Also our bank, Stranger Investors, SA, already have a relationship with Noor Bank and many other banks in the UAE, but SDLC can be sent only upon your acceptance and information to your bank. Kindly ask your concerned department to finish the formalities with the bank, including submitting of all documents relating to the deal. Your Honor, this is again an attempt on my part, this is again an effort on my part to convince the other party. And if you look into the sincerity of my effort, if you look into the manner in which I'm using the language and requesting them for help, it clearly shows that they did not want to proceed with this deal. My attempt was to convince them, since I have paid the money and I don't want to lose it, this is what you are supposed to do. Now, Your Honor, in the same tab, paragraph 29.
Just before you go there, I'm just trying to understand what your client's proposal at that time was. You keep on talking about transferring the SDLC, and I'm not sure whether you are talking about the instrument or the cash. If you're talking about the cash, since the instrument is due for maturity in a year, there can't be an instant transfer of cash because the discounted rate needs to be negotiated between the bank, the receiving bank, and the person who wants it credited to his account, i.e. the seller. So if that process is not agreed 3 ways, meaning the 2 of them and your client, then that transaction can't take place. Your client is saying get it transferred over first, and then we'll discuss the discounting. I'm not sure whether that's putting the cart before the horse. Mechanically, can that be done?
Your Honor, in the very next letter that I read out to this court, my client is even going one step ahead and telling this and telling the other party that I am now willing to bear even those 4.5% transfer charges. You please proceed. I will read that in a bit. But all that my client intended, Your Honor, coming back to your question, all that my client intended at that time was that he wanted, since it didn't work out with the Mashriq Bank, so he thought that they would transfer the funds directly, they would open an instrument, or they were the method that they were talking about with the Emirates NBD. So if an RMA is established, then it would be possible to transmit the funds through Emirates NBD. Now, this is
transferred by whom? By Mashriq? Mashriq Bank?
No,
or
not
by
the Mashriq Bank. The Mashriq Bank did not proceed at all.
Right.
So this was, the idea was that these funds will be transmitted from the bank. You will open an SBLC, we will, directly into the Emirates.
Sorry.
Money will come.
Who has to effect this transaction? The Strategic Bank on the one hand and Emirates Bank on the other, is that right?
That is correct.
So a new bank-to-bank
A new bank-to-bank
cutting out Mashriq.
Nothing about Mashriq.
Okay, nothing
a new
about
bank-to-bank. A new bank-to-bank transaction. This is what we requested. We said we want to exclude Mashriq, since Mashriq proved to be difficult in this regard, and we want to bring this directly under this roof. So it is.
But do we have any evidence that even Mashriq had agreed the terms of advising the SLBC, because I don't see any evidence of the actual discount rate that was going to be agreed. If they were to pay it out immediately, then somebody had to agree a discount rate with them at that moment.
Your Honor, earlier, that is not on record. Earlier, the agreement was that the seller would pay and whatever other discounting charges, they're not mentioned, would bear those discounting charges. Later, we find out from the evidence on record that those charges were 4.5%.
That's what Mashriq was going to charge.
That is what Mashriq will charge.
Yes. We do not know what Emirates would have charged.
Well, because the matter never proceeded further,
Yes.
Your Honor. So this issue never came up in that sense for discussion. But there is one letter subsequently which I would like to read.
Yeah, please go on. Please go on.
So that I don't miss the point. At paragraph 29, Your Honor, there is reference to on 2nd August, since I did not get any response from the claimant, I contacted the claimant's real estate brokers who had brokered this transaction to ensure that the claimant completes these obligations. I informed the claimant that I had already paid the relevant service charges and NOC. I just want to bring this letter to your attention. 2nd August 2015 letter is at running page 148, same tab. This is a letter that I wrote to the broker. This is the broker who brokered the deal. 148, running page, in a circle, small circle.
You've got it.
Yeah. Dear Mr. So-and-so, in continuation to a discussion and with the delay of Mashriq Bank to transfer the SBLC, during all the process of the deal, we also already tried to send the SBLC directly to your Emirates NBD account, and it was rejected due to non-existence of relationship between Emirates NBD and the stranger. Either provide us with one of your other account or help us in establishing the relationship between Emirates NBD and the stranger as discussed. Also, just bring to your notice, in order to finish this deal, we have already paid service charges, NOC fees, deposits in Emicool to complete the transaction. We are long-standing and very serious to complete the same at the earliest. From the above, we request from you as trustee to hold the above mentioned check till we reach an understanding to proceed with an understanding and complete the transaction with the IC. Hope the above information is clear and we complete the and we conclude the transaction in the relevant time frame. Now, Your Honor, the last two letters
what check are you talking about?
The check, the deposit check, because this 10 million deposit check was initially handed over to the real estate broker. The real estate broker was supposed to hold this check in trust until the completion of the transaction, until the money paid from the SBLC is received by the seller, and thereafter this check was to be returned to me. So my letter to the seller is, look, I have made every possible effort. Efforts are being made. We want to complete this transaction. We have paid all the charges. I would like you to hold on to this check that you have, which you hold as a trustee for me, and not give it to the other party to encash. Because the fear was that possibly the other party may possibly encash the security check. And at this stage, considering that they might argue that you did not complete the payments on time, and therefore we will proceed in this manner.
But you haven't referred us to the stakeholding agreement. What you're talking about is the stakeholding arrangement where the broker acts stakeholder.
Yes, Your Honor.
All right. So, you need to refer that to us at some point, not necessarily now.
Yes, Your Honor.
But ultimately, you've got to look at it because they encashed it presumably through invoking the stakeholding agreement.
Yes, Your Honor. Your Honor, in fact, we were not able to obtain, I was looking for this agreement because they would have executed an agreement into this effect, and that's why it's not part of the record. But I will try and obtain it.
Well, the other side can tell it up
Yes.
to us because they will have to justify their actions anyway.
Yes, Your Honor.
So move on.
Yes,
Well,
Your Honor.
the contract provided that the deposit security should be paid to the seller. Doesn't actually provide for the check to be held by a broker at all, did it?
But Your Honor, I just want to bring to the attention the practice in UAE. In all commercial transactions here in UAE, the ones I have been a part of, it's the broker who holds the security deposit check until the completion of the transaction. More like let's say more like an escrow. Not exactly, but I haven't seen the typical traditional escrow agreements being executed between the parties.
So that although the contract actually provides for payment of the deposit, in practice what happens, you're telling us, is the check is simply left with the broker.
This is the practice, Your Honor, and I speak based on my very limited interactions here with the property deals.
But so up to that, up to the point of the termination of the deal, the seller had not received any payment?
Up to the termination of the deal, the seller had not received any payment, Your Honor. We were trying to establish this relationship, and this was my main concern. And you will see, Your Honor, what we did immediately thereafter.
Yeah, please go on.
However, now on the paragraph, I am on paragraph 30. However, despite these regular, paragraph 30, page 127, running page 127, same tab, second witness statement. However, despite these regular follow-ups and our attempts to complete the transaction, the claimant deposited the security check in the bank. Immediately, upon receiving the word from my bankers that the security check had been presented, Your Honor, this was presented on 3rd of August, the security check, I believe. I sent a detailed letter. This letter is what I want to read to you. To the claimant, once again confirming my commitment to ability to close the deal and complete the transaction. I expressed my disappointment at the claimant's decision to deposit the security check while the transaction was still ongoing and negotiations were continuing. Now this letter, dated 3rd of August, is at page 150 of the same tab, running page 150. Easy to read. If Your Honors have it, are at page 150, with your permission, if I may read.
Okay. Yes, carry on.
Dear Mr. Saleh, in continuation to my letter sent on 29th of July, and also in continuation to our meetings, we have been trying to complete the deal from day one. Also, as mentioned before, due to delay of Mashriq Bank to transfer the SBLC during the process of the deal, we also tried to send the SBLC directly to your Emirates NBD account, and it was rejected due to non-existence of relationship between Emirates NBD and a stranger. During all this negotiation, we did not expect you to deposit our security check, as we are still under negotiations to complete the deal. We are still willing to be able to complete the deal. As per your requirement, we already agreed and undertake to pay the discounting charges. Now this is important. As per your requirements, we already agreed. So there was a requirement, we had discussed this in the meeting. So the issue was, you are going to pay the discounting charges. We said, as per your requirement, we already agreed and undertake to pay the discounting charges. And is also mentioned in our letter of 29 July, during this time we were waiting for a reply on the letter sent to you, and we get a call from the bank about the check. Through this letter, we again mention our stand and ability to close the deal and complete the transaction based on the following conditions. Number one, DIFC shall do their part of the documentation with your concerned bank required to complete the transaction to receive the SDLC in your bank account directly from our account in Estrangera, Brazil. Once the SDLC is received in DIFC's bank account, DIFC shall start the process of discounting the SDLC. We hereby confirm that all charges borne for discounting the SDLC shall be paid in full by us, and DIFC shall receive the full sale amount of 107 million for the 72 units, which includes 2% land apartment, to be paid on our behalf for the title deed transfer charges. In addition to this, we shall also include 4.5% of the total amount to the SDLC. This is very important. In addition to this, we shall also include 4.5% of the total amount to the SDLC to cover the discounting charges to be incurred to encash the SDLC. So we are talking of the Emirates NBD Bank here.
Sorry?
We are talking of the charges which are being payable to Emirates NBD Bank.
But how do we know that Emirates NBD have agreed to 4.5%?
That I don't have. That part.
I mean, they hadn't even agreed to do the deal at all.
Well, that because the transaction did not go through, Your Honor. So unfortunately, there is no evidence.
So this is a hypothesis, maybe based on what the Maastricht Bank had been charging.
Or maybe there were some discussions which my client may possibly have with Emirates NBD. But I cannot
let's leave that
provide
open.
evidence.
Okay.
Yeah. Once the DIFC completes the discounting and receives the full amount in your account, and we shall go for the transfer of the property in Dubai Land Department, we shall also need to make an amendment to the existing MOU Form F, mentioning the above also, and our bounce check to be replaced by a new check. If in case...
How was this expected to work when, as it said in the first paragraph, Emirates NBD had rejected the standby letter of credit because of non-existent relationship with their strategic?
Because
how is this going to work?
Your Honor, all that we are asking them is, now in order for Emirates NBD to process any request, they will need two things. First is the copies of the Title 72 title deeds and the sale and purchase agreement between the parties.
That's when it comes to present against the letter of credit. But the Emirates, like Maastricht, are not playing ball on the letter of credit, are they? They won't be an advising bank. They won't be an accepting bank. They won't be a correspondent bank because they've got no relationship with their strategic. So how's it going to work?
Well, we wanted the relationship to be established, and we wanted them to provide the documents to Emirates NBD banks in order for Emirates NBD Bank to establish a relationship with this bank. The point here is that Emirates NBD Bank did not reject this on the same grounds as Maastricht did. Emirates NBD Bank did not have an opportunity to consider this proposition, because the relationship was not there in place. They rejected it because there was no relationship in place. They could not have possibly processed it. So this is what my client, in his very simple language, was trying to convey to the other party. If I have your permission, can I complete this letter, Your Honor?
Yeah, but what you are submitting now,
Yes, sir.
I still cannot relate to time of essence. Is it still relevant to time of essence, or is it something else now?
Your
Is it
Honor,
just creating, asking us to be sympathetic with you? Because legally speaking, what did the other party? How did the other party respond to you all these correspondences? How did they respond?
There are 3 letters from their side, which are on record: 11th August 2015, 25th August 2015.
What did they say?
In those letters, they say that we have already notified you that we don't want to proceed further. We have already terminated the agreement. Now,
so they say, I don't want to talk to you anymore. I've already terminated.
Yes, yes.
So you are still pleading them to reopen the negotiation.
Your Honor, there are a couple of things which, if you let me come directly to your inquiry, because I think more or less, if you look into these, but I would request Your Honors to also look at one last page, which is my letter dated 25th August, letter to the claimant. And after this, I will come to that point how this is relevant. This is at page 153. This is a tab.
Sorry, by the way, page 151, first paragraph, just to conclude your client's proposal. If in case we are not able to conclude the deal on the mentioned terms, if agreed by DIFC, we can then undertake to go as per the MOU Form F. Now, what is that a reference to?
In case we are not able to conclude the deal on the mentioned terms, if agreed by DIFC, then we undertake to go as per Form F. Now, if you see Form F is nothing but the format of, I will take you through Form F right away. It is the format of how the sale and purchase agreement between the seller and the buyer. Now, under Form F, I have a right, meaning I'm telling them, I'm rather giving them a warning that in the event that you do not comply, I have a right to terminate this contract and demand my check back or claim damages or whatever is written in the contract, whatever is
That's to be
permitted.
given by whom to whom? By seller to buyer.
Well, I am the buyer, so I'm saying that if you don't perform your obligations, I will be constrained to seek appropriate legal remedy. The appropriate legal remedy mentioned would be return of my security check, which you have, and claiming all the money that I have paid to you as service charges and other things in the form of damages.
Sorry, but Form F is a form applicable to the seller or to the buyer?
Both. It is I will just take you through Form F. It's bundle form.
And what is the existing MOU?
It
Is that the
based
sale
on
and
Form
purchase
F.
agreement?
Existing MOU is also based on Form F.
No, but in the context of this deal, what was the existing MOU? Is it the sale and purchase agreement?
It is the sale and purchase agreement, Your Honor.
The one that we have looked at before,
One that we are
spells out
going
the
to-
terms.
Yes, one that we're going to look at.
Okay, and then Form F now you're going to show us?
Yes, Your Honor. It is at tab 30, bundle 4, tab 30.
Yeah. 30 or 13?
30, Your Honor. Tab 30. Bundle 4.
But these are all blanks.
Well, this is the format. All that we do when we do these property transactions here, we follow this format as far as possible.
And this was used for
This was used
current
for
deal.
This absolutely. And Your Honor, we also see there is clause 6, which is the clause I'm going to talk about shortly.
Why do you refer to as MOU? It is a contract, property sales contract, or just matter of terms?
I think, Your Honor, this is a letter which he has written.
Okay.
So his understanding of
Is an MOU.
normally
But he was referring to this.
he's not a very
Yeah,
educated
I
person,
understand.
so he may not have understood the difference between the two.
Okay.
Yeah.
And now on the last point of this issue, efforts to resolve this 25th August letter, which is page 153. Saying
No,
that-
do you want to highlight something from this property sales contract?
I
In answer to Chief Justice's question just now,
yes, Your Honor.
referring to MOU,
Yes,
and you took us to this form
yes.
at Appendix 30. So
Yes.
is there anything you want to highlight us here?
Well, I just want to highlight here that what we have in this agreement is that in the event, clause 7, in the event the seller fails to complete the transfer on the agreed date due to his own act or omission, then the full deposit will be refunded to the buyer. This is what I refer here,
Oh, I see.
clause 7.
Okay.
And also the seller agrees to pay the same deposit amount to the buyer as compensation. So now here I'm asking for 10 million. I'm telling them in this letter that you comply or I will go after Form F. Form F gives me the remedy, which is also by the way in our SPA, that you pay me my deposit back and pay me an amount equal to the deposit as compensation. So this was the reference to this particular document. Your Honor, with your permission, the last document I want to read on the subject is at page 153. This is a letter that I wrote once again to DIFC. DIFC. I thank you for your time for meeting held between 20th August Thursday with reference to the deal between us for 72 units. In continuation to a meeting, we have submitted you to SBLC as per the following. We opened SBLC 1 with reference to so-and-so for an amount of so-and-so, and SBLC 2 for an amount of so-and-so. Now we opened an SBLC 2 also, a second SBLC we opened for an amount equal. We wanted to open an amount for an amount equal to the deposit. Since that security check was presented, we opened a second SBLC as per the following. for the amount so and so. We have in total transferred 117 million in the form of irrevocable confirmed SPLC against the deal of 107, which includes 2% transfer fee to be paid against the total amount of so and so. We also agreed to pay the discounting charges as per our letter dated so and so. The SPLC sent shall cover the discounting charges to be paid by us. At this moment, also as mentioned in the meeting, we already transferred the SPLC and I don't have anything else on my name. I'm waiting for your kind selves to send me a reply on the meeting held and hope you understand my position at the moment. I have fulfilled the required as per the letter of intent and signed the MOU. I look forward to your urgent reply. Now, Your Honor, I want to make, why did I refer to, the reason I referred to the two sets of situations. First, prior to the termination, and second, after the termination, was to bring two critical points to the attention of the court. If we look into this whole aspect, again, this evidence has to be viewed in the context of this case as a whole, but at this point, in specific reference to the proposition that I'm going to make before this court. If time were to be of essence, why would the claimant wait after the cut-off date of 18th June 2015 until 8th July 2015 to terminate the contract? The effect of, Your Honor, the point I'm trying to drive here is, the effect of not terminating the contract immediately after 18th June is that the claimant cannot argue that time remained of essence, as he was required to serve a notice to the defendant. He had to serve a notice upon me after this date before terminating of the new termination date before exercising his right to terminate the contract.
What's your authority for that?
The authority I'm referring to is at Bundle 4, tab 31, page 91. If I may summarize this case first, if Your Honor.
Let's find the case before you summarize it. Tab, Bundle 4,
tab 31, page 91. I apologize that I was not able to include this authority earlier as a part of my submission, and it was only yesterday that I included it as a part of Bundle 4, and I apologize for the court and
There was a separate paper you said, is it?
It's the last tab.
This is the last tab. I think the separate papers is from the counsel for the
last step. The last step. Okay. Sorry.
Now, Your Honor, this is a very interesting case. To summarize, the facts of the case are that in February 2014, this is an English authority, in Hakim Zay versus Suarez. In February 2014, the seller and the purchaser signed the contract for the sale of a residential property. The long stop date for the transfer of property was 3rd April 2014. The property was occupied by a number of tenants under an assured short hold tenancy. After the contract was signed between the buyer and the seller sought to bring the short tenancy to an end. Unfortunately, for one of the tenants refused to leave, and the property transfer could not take place on the agreed date of 3rd April. Subsequently, a new completion date was agreed amongst the buyer and the seller as 29th April. This date also was missed by the seller. Subsequently, the seller informed the buyer about the new date as 2nd of May 2014. However, due to certain reasons, the buyer could not take possession on 2nd May 2014. Now, it was the buyer who could not take possession on 2nd May 2014. Thereafter, by a letter dated 6th of May, so just a few days later, 4 days later, the seller sought to terminate the contract. Towards this end of March, the seller solicitors notified the buyer solicitors that they were having difficulty getting a vacant possession. the 3rd April completion date was missed, and the buyer served a notice to complete, which expired on 29th April. Now, Your Honor, if you look into this case, before I go into what was held, and I will take you directly to the relevant paragraphs of this case. So, this is again a case where parties agreed, where time was of the essence, parties agreed to a given date. The seller could not perform the contract. Seller changed the contract from 3rd April to 29th April. Thereafter, he changed the date from 29th April to 2nd of May. And the buyer was supposed to perform the contract by 2nd of May. But what happened is, by 6th of May, since the buyer could not perform the contract by 2nd of May, so by 6th of May, they terminated the contract. And this is what the court held. I invite the attention of this court to tab 30, page, tab 31. This is the last one.
We're still looking at the case report, right?
Yes, Your Honor.
Yes.
Same case.
Right. What page?
Page, I will just take it on this. Paragraph 24, which is page 96. This is just, these are 2 paragraphs which are relevant. Not only does the Birkland case lend no support to the position contended by Mr. Wallford, that position does not make sense. To say that time is of the essence of a contract is not to make a metaphysical statement. It is to identify the fact that a failure to comply with a contractual requirement as to time of performance, whether that requirement be a provision of a contract itself or arise pursuant to a valid notice, making time of the essence, will itself amount to a regulatory breach. For time to be of the essence of the contract requires conceptually that the time be fixed, that the purpose of a notice to complete. The court holds now to say that time remains of the essence of the contract for a reasonable period after the expiration of the notice to complete. And this is our case, in the sense that the further time period after the expiry of notice is itself of essence, even though no new time has been fixed, is not to misunderstand the Birkland versus Farmer and Moody, but to say what is literally nonsense. It rests on a conceptual confusion. Paragraph 25. It may also be noted that the claimant appears to have been allowing the defendant to seek to remedy his defaults as shown by so-and-so in such and such case. If the party who is in the right allows the defaulting party to try to remedy his default after an essential date has passed, he cannot then call the bargain off without the first warning the defaulting party by fixing a fresh time limit reasonable in the circumstances. Therefore, in such circumstances, the claimant cannot simply pull the plug on the contract, so to speak, without fixing a new date that was reasonable in the circumstances. It must follow that the defendant could not do so either. He could not just turn around and say, I require you to complete forthwith. If you cannot, I shall terminate on account of a regulatory breach. Because during this continuing period, after expiration of notice to complete, time remains of the essence. 2 propositions I want to bring to the attention of this honorable court. First, if time is of the essence, it has to be construed very strictly. If 18th, in the instant case, if 18th of June was the cut-off date, then 18th of June remained as the final point. Then we cannot presume, there's no presumption in a situation where time is of the essence, that since time was of the essence until 18th of June, time will continue to be of the essence for any time thereafter until you reasonably exercise your right. What the opposite side has to explain to this honorable court, in my opinion, is the issue was, if 18 June was the time, you should have terminated the contract.
On the 19th.
On 19th, on 20th. Within 1 or 2 days. I would consider that as reasonable.
I think the case law won't support you on that. Conveyancing practice doesn't work that way. You fix a time for completion, and you tell them that time is of the essence, and then if they don't, then at any time thereafter, the vendor or the purchaser, as the case may be, can terminate, right? Subject to any other equitable defenses that might be raised. At the moment, I don't see any in your case.
Your Honor, I'm coming to that. That is exactly my next argument.
But you are arguing it from a point of view of basic common law. I'm telling you, the common law of conveyancing doesn't require that once the time of the essence date has expired, the vendor or the purchaser, as the case may be, must exercise his right of termination the next day.
Your Honor, while the common law proposition stands as it is, this case has to be this proposition, which I quoted before this Honourable Court, has to be viewed from the perspective of the facts and circumstances of the case. Now, I want to bring in a very critical aspect in this case. The claimant is seeking a declaration in this particular case, saying that that I have effectively terminated all the contracts. Now that is a declaration they're seeking. And they're saying we are seeking a mere declaration and nothing more. However, if I take you through the particulars of the claim, you will notice one more thing out there. That one more thing is, I hereby reserve my right to claim damages, to claim other compensation.
But he hasn't actually claimed it.
They have not claimed it, but they have reserved their right.
So when he stands up, he'll have to elect, and he elected before the judge not to make any further claim.
Your Honor, I'm exactly, if you give me 2 minutes, there's a point in my mind that I wish to convey to this Honourable Court. I am arguing that if time was, look at the facts and circumstances of this case. We had several meetings after they said this is the cut-off date. And in those meetings, we even negotiated that I will pay for the transfer charges. I had more than just a simple interest, because my money is blocked when I open this SDLC. I have a compelling interest to ensure that this transaction is complete. But if you look at the facts of this case, the moment this check, which was the security deposit check, it appears to me that it's more of a case to say that the security deposit check which you have given, we have rightly deposited the security check. So we have a claim over 10 million. My position is, now if I look into the equitable side of the argument, if I present the equitable side of the argument, where is my client? My client has been imprisoned by the criminal court because the check has bounced.
Why did the check bounce?
Because at that time, when they encashed the check, at that time he did not have
The fund.
Sufficient funds in that account. And as per UAE law, when you write a check, and if at that time you didn't have sufficient funds in your account, the court will hold that you did that with a bad intention. Now this issue came up in a criminal case before the Dubai courts, which they had filed. And this judgment on the criminal case came on 13th of April 2016. In this judgment, the court went into these reasons, and he gave all the reasons which I have given before you, and the criminal court said, we are only concerned with the fact that you wrote a check, and it was a bad check, and we hold you liable for 3 years imprisonment. Now, the difficulty when someone is in this position and not freely able to move and not freely able to do business, the difficulty arises, and I could be completely wrong, and let me say that I seek your guidance really, if that were to be so, is what would he do if you give a declaration, if you confirm that this declaration is correct? One of the things that can possibly happen, while they may not go and file another claim against us seeking damages on the basis of the declaration that they will get from this honourable court, I don't have a choice. After that, once you declare that this contract has been effectively terminated, Your Honours, what choice do I have to come before you, to file this case in DIFC courts and say the check was wrongly presented? Because I want to come out of that prison. I want to come out of that that sentence against me should be suspended. And the only way I have to do that is because I initially went, Your Honor, to the Dubai courts, and I filed a claim against them that I've opened an LLC, I've done everything, and they should perform their part of the contract. This decision came on 2nd of March 2016. My case was dismissed by the Dubai courts. Dubai court said, we do not have jurisdiction. You have to go, this is a company in DIFC, you have to go to the DIFC courts. My case was not adjudicated on merits, it was dismissed. Now if you hold that this contracts have been effectively terminated, under which provision of law can I come before this honorable court and argue that, Your Honor, the check, if I want to bring, I have not brought a counterclaim, it was a party proceeding. I did not, I was not in a position to bring other evidence and things at that point in time. I was only defending the party proceeding. That's why you don't see that much of witness before you. But what do I do in a situation, Your Honor, where I have no option left? I will be in prison, or I will be in a different situation. The equitable argument here is that if you give a judgment that all contracts have been validly terminated, I have nothing, I have nowhere else to go. I cannot come before the DIFC courts, and I cannot re-educate the matter and say, on the basis of this contract, which has been terminated by the DIFC courts in such and such decision, I am seeking to reopen the case and say that the check was wrongly presented. I did not get an opportunity to present this argument.
You had the opportunity in this case.
Your Honor, I have brought this attention to your case before this court that my check was wrongly presented by them. It was a security check.
But you haven't made a defense. You haven't made a counterclaim.
We have not.
You haven't brought a cross claim.
We have not brought a cross claim, unfortunately,
Yeah.
Your Honor.
I mean, but you had the opportunity to do all of those things.
Your Honor, we were just trying to defend the party proceeding in the sense that bi-party proceeding is not applicable in the given case, and that's what we tried to do in before the court of first instance. Now, in this particular case, Your Honor, I was only on the issue of equity. It will amount to unjust enrichment, because let's come down to the most important point, which is clause 6. What is clause 6? I'll read it out to you as well. But the summary of clause 6, let's forget that there is a disagreement between us on whether this qualifying phrase would attach to condition 1 and condition 2. Let's forget that. Let's go to the second part of clause 6. It talks about if there is a violation. And the clause 6 is the only provision in the entire contract which talks about their right to forfeit the earnest money that I have paid, their right to take over my money. And so it is a penalty clause. So how would you categorize this? What would be one way of categorizing clause 6? I would say the one way of categorizing.
What is the percentage of the purchase price that the security?
10%.
Yes. There is authority that a deposit of 10% is not a penalty. In the Privy Council, by the way.
Your Honor, 10% may appear to be very reasonable. But given, that's why I read out these circumstances. Because the evidence that we have on record, Your Honor, brings us to a very critical point, which is, what was my obligation as a buyer? My obligation was to make the payment of money. What was their obligation? To complete the transfer, to do all that is required to be done once they receive the money. Now, in their submissions, they have written that SDLC is as good as cash. Now, in this, the facts and circumstances of the instant case, Your Honor, will show two things. One, I did what I was required to do. When my SDLC with Mashrik Bank did not work, I tried to contact them and said, I would like to establish directly a relationship with the Emirates NBD Bank. And now all that they had to do was, there were several meetings held between us to provide the documents. And if it would have failed at that time, the relationship between Emirates NBD and us, then clearly it was a completely different scenario. Here, whatever happened, it was not an intentional. The point is, was it intentional non-payment on my part or not? And this brings us to the crux of our case, which is clause 6. Now, if you read clause 6, Your Honor, if you allow me, I want to read clause 6 because I want to take you through two critical observations that I have in that regard.
Yes. Sorry, what do you want us to look at, please?
Article 6, clause 6.
Of the contract?
Of the contract. Bundle 4, tab 1.
I think it's tab 4 of bundle 1.
Yeah.
Tab 4.
Yep. Tab 4.
This is a running page 28.
Yes, we have here there.
Your Honor, this is the crux. I have dealt with this subject extensively in my two skeletons. So I will not take you through every point. I would rather focus on the sum and substance of my argument. Article 6 or Clause 6, I refer to sometimes as Article 6 and sometimes as Clause 6. My apologies, it should be understood as the same thing. In the event, so there's a clause which says in the event the buyer fails to pay the payments as signed, as agreed, date in clause 3, and then there is a word or. So again the word in the event still remains there, or fails to complete the transfer on the agreed date. So there are two situations. There are two negative conditions. Let's look at the type of conditions. Are they positive conditions or are they negative conditions? If they are positive conditions, they are to be read conjunctively. If they are negative conditions, they will have to be read separately. Now, in this particular case, Your Honor, these are two negative conditions. In the event the buyer fails to make the payments as per the agreed date in clause 3, or fails to complete the transfer on the agreed date, due to his, now this is the point, due to his own act or omission, then the seller has the right to terminate this contract, and he shall be entitled to retain the deposit as long as the termination of the contract was due to a violation of the agreed terms, unless they agreed amicably. So there are a couple of issues that arise in clause 6. First, there is a qualifying phrase which says there's a situation in the event the buyer fails to make the payment as agreed. And then it says fails to complete the transfer on the agreed date. Now this word due to his own act or omission, this word due to his own act or omission qualifies both phrases, my ability to pay and my ability to complete the transfer. We just saw, to highlight my point, we just saw Form F. If you see Form F in closer detail, it says that if you, now the next question is, what are the obligations of the buyer? The Form F says, obligations of the buyer are to make the payment, to pay for, I paid for NOCs, I paid for service charges, and now I have to pay the purchase price. That was my obligation. And I even had issued in this PLC where 2% transfer charges for transfer property with it. I had no other obligation. All other obligations were there of the opposite party. Now, if we look into this clause, and if we look at the clause from this perspective, what my obligations are and what my obligations could be, and you see what is the relevance of not reading, my learned counsel on the other side has in his skeleton argued that this condition does not attach to the first thing of payment, because payment has to be made in any event. So, if you fail to make the payment, you are in the wrong. But I am arguing, unfortunately not, simply because this is a forfeiture clause. This is a penalty, because this is the only clause where you have the right to retain my deposit. I cannot be penalized if I did not, if it was a situation beyond my control. I will shortly bring you, we were asked by the court of first instance that can you translate Article 6 as written in Arabic into English? We have that translation. I'll take you on that. In that phrase, the terms used are beyond the control. Here, the terms used are if due to my own act or omission. It means, in effect, the same thing. I cannot be penalized for something when the circumstances were beyond my control. So I feel, in my particular submission before this honourable court, Clause 6 is the quintessential argument, is the most interpretative clause that cannot be ignored by the honourable court. By ignoring Clause 6, what the court did was, court ignored all other circumstances. Clause 6 represents the agreement of the parties. This is what we agreed. I'm giving you a security deposit on the condition that this security deposit shall be retained by you only in the condition if I fail. Now, if I fail intentionally, with my own act or omission. Now, I should have done something wrong. There should have been some act on my part that was wrong.
Omission. Act or omission.
Act or omission. Or omission, something I was supposed to do that I didn't do.
Yes.
And now, you may well argue that you did not pay the money. So that is an omission on your part. I'm afraid I would argue it the other way. I would say that an omission, I would have omitted to make the payment of money only if I did not open an SDLC, only if I did not make the measures. Now, if you look at Article 80 in this regard, Article 80 becomes very critical. Now, the opposite party argues Article 80 does not apply. And I'm
sorry.
The DIFC
18 or 80 of what?
80.
80 of what?
The DIFC contract law. Yeah.
Bundle 3, tab 25.
Which? Bundle 3?
Tab 25.
Tab 25.
Yes?
Page 352. Article 80. Now cured by the non-performing party. The non-performing party may, at its own expense, cure any non-performance, provided that, without undue delay, in my case there was no undue delay, Your Honours, it gives notice indicating the proposed manner and timing of the cure. You saw from the documents, I gave a plan of action. I told them what I want to do. The cure is appropriate in the circumstances. The cure is appropriate in the circumstances because I have paid the earnest money. I have paid other fees. And it is in my interest that the contract must be performed. The third ingredient, the aggrieved party has no legitimate interest in refusing cure. Well, if they refuse without any just reason, making time the essence of the contract when it's not, it would amount to unjust enrichment, I'm afraid. Because you cannot take away my money when I'm willing to perform, and when the delay in the SDLC was not on account of my personal reasons.
Why do you want to go down a complicated route of unjust enrichment when you simply say you're not entitled to take my money because it's not allowed under the contract?
Your Honor, I was just referring to one of the consequences, that one of the possible ways, if someone were to take away my security deposit at a time when...
He can only take away your security deposit if the contract allows him to do so. And if the contract allows him to do so, there's no unjust enrichment anyway. So why don't you just argue it in terms of the contract?
I would like to argue in terms of Clause 6.
Clause 6 is the contract.
Clause 6 is the agreement between the parties.
Yes, it's the contract.
Yes. So, Your Honor, coming back to the issue of Clause 6, if you were to look at Clause 6, one thing is very clear. When I use the word omission, there is one point I want to make. These two conditions that I referred above, like in the event he fails to make the money, or in the event he fails to make the transfer. There is a book I came across interestingly, written by an Indian author, Justice G.P. Singh, and this is the Principles of Statutory Interpretation. And I was just trying to understand one clause. I'm just going to read one clause. Speaking generally,
This isn't one.
unfortunately, this was not we were not able to provide you a copy of it. There's only just one point that I want to convey. The point is, a distinction may be made between positive and negative conditions prescribed by a statute for acquiring a right or a benefit. Positive conditions separated by or, by the word or, are read in the alternative. But negative conditions, like these conditions, connected by or, are construed as cumulative, and or is read as nor or and. Now, this is just a simple principle of construction given in the instant case. If we look at clause 6, which talks about two conditions: in the event you do not do this, and in the event you do not do that, and they are separated by or, they should be read as together. And there's only one qualifying phrase, which is due to your own act or omission. I think the issue should not be whether this due to own act or omission relates to both the conditions. It does. The issue is whether there was from the facts of the instant case, whether there was an act or omission on my part. I have argued that I should have done something wrong, or I should have omitted to do what I'm supposed to do. In this case, given the scenario where my SDLC did not work, I did what I could. I made every possible effort, every possible attempt to seek the help of the other party. I did not, unfortunately, succeed. So you have a right to retain my security deposit only if I have done something intentionally. So the word, so now, Your Honor, the important point is the intention. There should be some mens rea. There should be some intent on my part if you want to forfeit my deposit. It's a penalty after all. A penalty cannot be imposed on a person without forfeiting the deposit is a penalty, without me having done intentionally something wrong. What the Honorable Court of First Instance Judge has done, he has looked at DIFC contract law and looked at Article 86.2. I want to bring Article 86.2 to your attention, Your Honor, and read with Clause 6 because it gives a completely interesting interpretation. Once again, I draw the attention of the Honorable Court to Bundle 3, Tab 20, Tab 25. Bundle 3, Tab 25. Page 365. Right to terminate a contract, Article 86. A party may terminate the contract where the failure of the other party to perform an obligation under the contract amounts to fundamental non-performance. The word used here is fundamental non-performance. In determining whether the failure to perform an obligation amounts to fundamental non-performance, regard shall be had in particular to. Now these are 4 things that must be borne in mind before we come to a conclusion if this is fundamental non-performance. The non-performance substantially deprives the aggrieved party of what it was entitled to expect under the contract. Here they wanted money, and they have not received money as yet, but they were also supposed to do something which they did not do in order to receive the money. The strict compliance, second condition, the strict compliance with the obligation which has not been performed is of the essence of the contract. Here the money had to be paid, but we have seen the conditions, they have not strictly treated it as time is of the essence because discussions still continued, meetings were still held, the charges, discounting charges were still being discussed, so it could not be said that they treated essence as the essence of the contract. The third condition is the non-performance that I'm relying on. The non-performance is intentional or reckless. Now, this is the point. My non-performance, yes, there is non-performance on my part because they have not received the money. But, Your Honor, my non-performance from the facts of this case is not intentional. It's not reckless. I did not intend and I did not act in a manner that was reckless. And the non-performance gives the aggrieved party reason to believe that it cannot rely on other parties' future performance. Clause 3, in case of delay of the aggrieved party, may also terminate the contract if the other party fails to perform before the time allowed.
Right. What are you reading from now, please?
No, Your Honor, I'm relying on 86.2, what I read just now. 86.1 and 86.2. Okay. These two clauses. So what is the essence of Article 86? The essence of Article 86 is that I have a right, I'm a party, I have a right to terminate the contract where the failure, again the failure of the other party under the contract amounts to fundamental non-performance. In my skeleton, I have explained this distinction. There is the reason why the word fundamental non-performance is used is because there's a distinction between non-performance and fundamental non-performance. The distinction would relate to the fact that whether the non-performance was reckless or it was intentional. Regard must be paid to this condition. In the instant case, I am trying to argue that yes, there is non-performance, but my non-performance was not in fact, the opposite party, as you can see in the submission, which I'll point out, they have said that we understand that it was not because of your fault, we understand it was because of Mashreq Bank was not able to transfer, but the fact remains that you did not pay the money, and the reason why you did not pay the money, and the fact that you did not pay the money, that is fundamental non-performance. And that is exactly what the Court of First Instance has held. The Court of First Instance has held that we did not look into Clause 6. We did not look into the effect of Clause 6. Why the claimant is arguing that I have terminated the contract on the basis of Clause 6. The Court of First Instance says no need to look into Clause 6. I need not decide or settle the controversy between the parties arising out of Clause 6. But I rely on Clause 86, and under Clause 86, the mere fact that you did not pay, without any regard to 86.2, the mere fact that you did not pay the money amounts to fundamental non-performance. I'm afraid my submission is, it doesn't. In my case, it is non-performance. In my case, it's not fundamental non-performance. They cannot rely.
But if you go back, this is application under Part 8, isn't it? And Part 8 refers to dispute of facts. I don't see there a dispute of facts in this case. The facts do not see. You're arguing on the law, you know. But
No.
I don't know. I'm not.
I will
because you know
I will respond to that.
yeah. So.
Look, if it assists you, counsel, the tribunal, this court will look at Article 6, all right? So you don't have to press that particular point, right? So we have taken on board. Now, right now, I'm just thinking what you said is very clear, but it's also very familiar because you make the point quite comprehensively in your written submissions. So I'm just wondering whether this would be a good time to stop so that we can get the other side of it, and I'm going to give you another chance anyway after. But I think we've got the thrust of your arguments. So would that be acceptable to you if we ask you to bear, unless it's a completely new point? But what you've been saying is now sounding very familiar to us, either because you said it earlier or because it's in your written submissions. So I think we would reflect better on that after we've heard the other side, then you can come back and respond to it.
Sure. I think that would be a better approach.
Yes, okay. Sir, sorry, just pause a minute. Yes, Mr. Patrick first.
I'm obliged, Your Honour. Your Honour, I hope that the court has the benefit of the original chronology, which was in Bundle 1 at tab 1, and also the respondent's skeleton argument, which is to be found in Bundle 3 at tab 24. And I anticipate from the exchanges that have just taken place between the court and the learned friend that the court has had a full opportunity to read both of the skeleton arguments, and I hope that the chronology provides at least an easy way in to all of the material which is set out in the skeleton arguments. So, Your Honour, for present purposes, I would intend, unless the court indicates otherwise, to take the contents of my skeleton argument, or indeed our skeleton argument, as read.
Yes.
And you will see that in some respects which may be parts which have fallen away to a greater or lesser extent. There is an incorporation of earlier submissions which were before the Court of First Instance. I have in mind particularly with regard to the language of the contract and Form 6 and Form F, and also in relation to the applicable law, whether it's DIFC law or UAE law. Those are incorporated by reference. You again have our submissions in that regard. I think the language point has probably fallen away. There is a live issue as to what is the applicable law, but we've analysed in our Skeleton argument what are the applicable provisions under the DIFC law, what are the applicable provisions under the UAE law. We've referred to some passages of the Learned Friend Skeleton where indeed the Learned Friend says that there is substantial identicality between the legal provisions. So I hope that, again, I can deal with that relatively quickly. What I would intend to say is really to pick up the points which have arisen in oral argument this morning and comment and make submissions in sequence. And according to my notes, they are as follows. The first point that I should deal with is the effect of the standby letter of credit. And there was an exchange between Honourable Justice Cooke and the Learned Friend in relation to the standby letter of credit. And in my submission, everything that was put to the Learned Friend by the court is indeed absolutely correct. And I have the note of my learned friend being pressed by the court that the Mashreq Bank had never advised the seller of the standby letter of credit which would constitute payment. And although at that time there was not reference to the particular provision, it subsequently was referred to, or subsequently particular relevant correspondence. It was a couple of minutes later referred to, and that is, of course, as the court pointed out, the letter to be found in Bundle 4 at tab 13, which is page 32 of the running pages of that bundle. That's a transcription of a rather unclear letter on the previous page. Please note that the SPLCs, and this is the Mashreq Bank writing to the learned friends, Mr. Mustafa, saying, please note that the SPLCs have been received at our counters and they're referred back to the issuing bank due to compliance issues. We have not advised these SPLCs to DIFC. So it's a point, I think, which is already fully before the court. But when pressed, the answer is clearly the SPLCs had not been advised. So there was no payment. There were also the question of amendments. And in that regard, there was the reference to the rather unclear copy of the there's a reference to the rather unclear copy of the standby letters of credit, which I think was to be found at Bundle 4, tab 6, page 15. And in an attempt to assist the court, I also referred to a copy of the same document in its original, the same document which then had manuscript amendments, which is to be found in Bundle 2, tab 9, page 134. So that if one begins with the letter of credit, the standby letter of credit in its original form at tab 6 of bundle 4, pages 15 and 16, there is some manuscript edition. One doesn't need to worry about those manuscript editions, I don't think, and there's some highlighting. But that was the original form of the standby letter of credit. If one then goes to the passage or the page that I've just taken the court to in bundle 2, one can see, beginning perhaps at page 133, which is the covering letter, refers in the first paragraph of the SPLC being transferable. To avoid risk for our customers, slight changes made as attached suggests the letter of credit be governed by ISP instead of UCP. And then if one goes on to pages 134 and 135, one can see that the first amendment was that the sum would be payable not at the expiry of the date of June the 3rd, 2016, but would be payable on or before the 3rd of June 2016. Now, small in terms of change of language, but very important in terms of change of effect. The second suggested amendment was that the words "upon presentation and surrender of the standby letter of credit via tested SWIFT message at our counters" be deleted, and the words "upon receipt by us of your demand in writing, either directly or through your bankers via authenticated SWIFT message" be substituted. And then if one goes over the page, page 135, one can see that the UCP paragraph has been scored through in manuscript, with a manuscript addition in the margin should be governed by ISP, and I think it must have been cut off, it should read 98. So what one has is not even an acceptance as to the form of the standby letter of credit. So going back to the exchange between the court and the learned friend, it was put to the learned friend that at no point has this SPLC ever been made available to the seller. The learned friend acknowledged that technically that was very correct. Well, there is really no technicality about this at all. It was not advised to my client. Then the court went on explaining the duty of the advising bank to authenticate to the third party, and if it refuses to do so, so it would say, and it was put, that is what happened. The money never became available to the seller. Now, if I may take the court to what we say in our skeleton argument about this in particular, if I could take the court to bundle 3, tab 24, page 340. And I apologise for picking this up mid-flow, but I hope the court will bear with me.
Which tab?
Page 340, paragraph 92. It's tab 24. Bundle 3, tab 24, page 340, paragraph 92.
Mm-hmm.
And this was dealing with some errors that had been included in the way that the learned friend had put his written case. The defendant has gone on to support his claim of error on the part of the court of first instance, with assertions that are either wrong or incomplete. It is said that, quote, the payments were actually made by the appellant through the standby letter of credit, and there's a reference to a similar erroneous claim being made at another juncture. That is incorrect. No payments were made. That is the point. It's then said it's not the appellant's fault if such payments were not processed by the correspondent bank for some compliance reasons. The apparently unchallenged evidence is that the correspondent bank, acting on behalf of the defendant, was prohibited from following his, that's the defendant's, instructions because warrants had been issued. If the defendant has conducted his own affairs and those of a company which he controls so as to trigger a regulatory prohibition, it in our submission most assuredly is his fault that payments are not processed as a result. The defendant has then gone on to claim that, quote, it is an admitted fact that the appellant took immediate measures to arrange for payments, but did not receive the support of the non-appellant, who was required to provide certain documents to the bank in order for the bank to process payments. It is not an admitted fact that the defendant took immediate measures, see the accompanying chronology, nor is it accurate to assert that the problem lay with non-provision of documents by the claimant. The problem lay at an anterior stage, i.e. the refusal by Mashrek Bank, for good reason, namely regulatory constraint, to follow the defendant's instructions. It is simply wrong to assert that there is a substantial dispute of fact, and this is a slightly different point. There is no dispute at all. And then, if I may take the
well, before you go there, the point that was being made was that, as it were, that one of the critical steps for the buyer to perform his obligations by trying to reroute the original payment flow by trying to establish a direct banking relationship between the Brazilian bank and your client's bank failed because of your client's lack of cooperation. I don't recall any factual material on your client's part as to why they didn't comply with that request.
Well, Your Honour, at that stage, my clients had sent the termination letter of the 8th of July.
Well, then that goes into the next question as to then why was there this long correspondence and communications and discussions with the buyer for apparently a revival of the deal?
Well, there was a period of time between the 18th of June and the 8th of July. In my submission, that is not a long period of time. And one might be criticised for acting immediately without at least listening to what the other party is saying. But the fact that you listen to what the other party has to say, out of courtesy or for any other reason, does not affect time being of the essence and the fact that payment had not been made according to a specifically agreed date, because of course you'll recall, Your Honour, that the original date had been earlier in June, it was the 7th of June, and there was an agreed extension to the 18th of June, and that was clear for as far as both parties were concerned. So the position is that the defendant was in clear breach. We listened to what was being said, but we did not take any step other than on the 7th or 8th of July, 8th of July, to write the letter terminating a notice.
Yes, but having terminated, then why are you going on to listen to the person?
Why did we terminate?
No, having terminated,
Yeah.
Why did you continue to have discussions with them and apparently make concessions in terms of what could be done to revive the deal?
With respect, this is again an error on the learned friend's part. There was a meeting, we received letters, but as you will have seen, Your Honour, those letters were saying, we look forward to an urgent response, we look forward to your advices. And we consistently went back and said, the contract has been terminated.
That's what we haven't seen so far. Can you show us those?
There were 3 more letters.
Yeah,
Yes.
he didn't take us to your letters.
Yeah, 3 times.
So can we have a look?
Yes, they are, first of all, could we go first of all to bundle 4, tab 20? Bundle 4, tab 20, the copy of the letter, the original copy, is not very clear, and then that has been transcribed, beginning at page 54. We refer to the property sales contract, 10% deposit was paid by you, etc. Thereafter, without prejudice to DIFC's rights under the property sales contract, DIFC, I'm reading the foot of the first page now, Your Honour. DIFC tried in good faith to accommodate your bank's requirements by providing with a letter dated the 14th of June, which we understood was not sufficient to release the funds of DIFC in favour of DIFCI. DIFCI also being asked to establish a link between DIFCI ENBD bank account and Estrategica, or to provide a substitute bank account. These were new requirements which were not entirely clear to DIFCI, and it's certainly not what DIFCI had originally contracted for under the property sales contract.
Sorry, the date of the encashment of the cheque was
3rd of August.
Sorry, was it August or 30th of July?
3rd of August, the encashment of the cheque.
Yes, it was a little bit unclear, somewhere around either 29th of July or through the
I'm looking at page 55, it seems to be 30th of July. So was there another date? I've got it as 30th of July. On page 55.
Well, I think it was presented.
So that was after your termination.
I don't think that there are a number of dates between, I think, the 29th of July and the 3rd or 4th of August.
Well, no doubt it was presented on one date, and the notice of dishonour was given
I think that's probably
later
right.
on.
Yeah. That's certainly how I understood the difference.
So right now your clients don't have any money from the buyer.
Well, because they held the security deposit, which was
but the cheque
provided by way of cheque on or about the 3rd of June.
Yes.
Then, in the light of the termination...
So your clients don't have any money arising from that cheque or
No.
by any other payment?
No,
So-
absolutely nothing.
Right, but you're not claiming damages?
The claim has been put forward on the basis of seeking a simple declaration.
Yes.
That is all that was put forward before the court of first instance, and that is all that is being sought to be upheld before this tribunal, before this court.
And an order was granted just in those terms. So the order of the judge is that there is a declaration and presumably some costs to be paid. Is that right?
Indeed, and the declaration was a declaration that the contracts had been terminated on the 8th of July 2015.
Had been validly terminated.
Validly terminated, yes, indeed.
But this letter you're referring to is dated 11th of August 2015.
Yes.
And in paragraph, the penultimate paragraph, you state here, the DIFC hereby wishes to terminate the property sales tax through your failure to pay. So, if you read that hereby, means you are using this letter to terminate, which is dated 11th of August.
Well, I think that we've seen slight difficulties in the use of the English language in other letters, and in our submission, this letter has to be read as a whole, and that was why I was looking at the foot of the previous page, where what is set out is the circumstances after the middle of June, and what was made absolutely clear in the course of this letter, as indeed is correct, is that what was then being put forward by the defendant appellant were new requirements which were not entirely clear either to the DIFCI, nor were they what the DIFCI had originally contracted for under the property sales contract. So that I fully accept that the passage that you've drawn to my attention, Your Honour, is stated there, but it must, in my submission, be read in context, because one continues at the top of this page. By the 18th of June 2015, you were unable to abide by your obligations under the property sales contract. And at that point in time, it was perfectly legitimate for DIFCI to encash the 10% security deposit as per clause 6 of the property sales contract.
But there's no reference to your letter of termination of the 8th of July.
No, but there's no suggestion that, it's not suggested that that wasn't received, and therefore it's part of the factual matrix.
Can we have a look at the 8th of July letter? Okay?
Yeah. Before that, you were reading the last paragraph of page 1 of the letter you were referring to. Even that sentence says, thereafter, without prejudice to the DIFCI's rights under the property sector. In other words, you're reserving your rights. You're reserving by this last paragraph. You say that thereafter, without prejudice to the DIFC's rights under the property sales contract. You are reserving your rights. In other words, I read that as you have not terminated yet. You are merely reserving your rights.
I think that relates to the I think that relates to the reservation of right in relation to pursuing other remedies beyond terminating.
And then it goes, the IFC tried in good faith to accommodate your bank's requirement by providing you with a letter dated 14th of June 2000, which you submitted to the bank, but which we understand was not sufficient to release the fund in favor of the IFC. The IFC also been asked to establish a link between, and these were new requirements which were not entirely clear to actually, and that is entertained. Certainly not what the IFC already contracted you in. By 18th of June, you are unable to abide your obligation under the property sales contract, and at that point in time, it was perfectly legitimate for this to encash the name as per clause 6. The security deposit was deposited, and anyway, that given purpose.
Yes. So that in our submission, this has to be read as a whole. And what was being made absolutely clear was that as of the 14th of June, there had been a proposal which was marked...
Is there any other letter before this?
Yes, is there any other letter before that? Well, there's the letter of termination, which you've already seen, which is the 8th of July.
Can I have another look at the letter of July?
Yes.
Tab 15. Tab 15. Same bundle. Why is it?
Page 42.
Yes, tab 15. So we're writing with respect to the above-mentioned subject. We refer to the property sales contract that was signed on the 3rd of May, which expired on the 7th of June, and the subsequent extension to the original contract signed on the 7th of June, which has now expired on the 18th of June. Please note that we have provided you with the NOC from the master developer authorising the transfer of the 72 units into your name. However, you have failed to submit a valid, irrevocable standby letter of credit by the agreed date. Accordingly, we now exercise the right, as per clause 6 of the contract, to terminate the same and encash your security deposit of 10 million odd dirham, which is currently held by blue chip real estate broker. So, clear. Absolutely clear.
Yeah, so go on after, what's the next letter after the 11th of August?
There's a letter on tab 24, which is the letter of the 25th of August. And again, it's been helpfully transcribed, so perhaps looking at page 63 would be better. We refer to our letter dated the 11th of August and our meeting on the 20th of August at the DIFC offices. DIFCI reiterates its position that it no longer considers itself bound by the property sales contract, given that, one, you were in clear breach of your payment obligations thereunder by inappropriately addressing the SPLC to your company, namely Emirates Moon Trading LLC instead of DIFC Investments as agreed, which resulted in this payment being blocked by Mashrek Bank, and two, you were unable to remedy the breach by having the said SPLC transferred into DIFCI's name despite reasonable efforts made by DIFCI to accommodate your bank's requirements. When the SPLC could not be cleared and your deposit cheque got bounced, DIFCI did mention to you, as a matter of good faith and without prejudice, DIFCI might be willing to consider accepting a manager's cheque as the only mode of payment for the total purchase of the property. However, at the meeting held on the 20th of August, we were surprised to learn that you had, without prior notification to DIFCI, issued two SPLCs, two further SPLCs, in DIFCI's name at Mashrek Bank. One issued giving the reference for 107 million dirham, and another giving further references in the sum of just over 10 million dirham. We fail to understand how you've obtained access to DIFCI's confidential bank numbers without authorization. We further note that one bank account is incorrect, the other bank is a trustee account, whereby DIFCI is holding funds on behalf of beneficiaries. As DIFCI is no longer bound by the sales contract, we would be grateful if you would please arrange for sufficient funds to be deposited in your bank accounts to honour the security deposit to which DIFCI is entitled under the property sales contract. Again, the purport of the letter could not, in our submission, be clearer. And then, to complete the picture, could I ask you to turn to the next tab, which is tab 25, which I think is a letter dated the 26th of August, though the precise date is unclear, but I think it's the 26th. Again, on DIFCI note paper. Thank you for your letter dated the 25th of August.
Sorry. Let's have that number again.
It's the next tab, Your Honour. It's tab 25. Should be running number, page 64.
Yeah, okay. Sorry, but it refers to another letter of the same date.
I think it may be. I think this letter is dated the 26th, and it refers to a letter dated the 25th of August, which is a letter I think the friend has already taken into existence.
Page 62, isn't it?
Yes. I think we may have seen it in bundle 2. Yes, I think actually my learned friend took you to it as bundle 2, tab 9, page 153. But it doesn't matter, we've got it in duplicate. So he's referring to the letter of the 25th of August. And says, thank you for that letter. Please refer to our letter of the same date, which is the letter we've just been looking at, back at tab 24. Please refer to our letter of the same date, which is self-explanatory, and whereby DIFCI reiterates its position that it is no longer bound by the property sales contract. Again, absolutely categorical in our submission.
Have you finished all the letters from your client now?
There's certainly 3 of the letters. I couldn't stand here without checking to say that that's all of them, but it's certainly 3 of them.
Okay. Right.
And I took you by way of summary to what we had said in paragraph 92 of our skeleton, Perhaps I can also, whilst we're looking at the standby letters of credit, take you back in the same bundle, which is bundle 3, same tab, which is 24, to page 333.
Did you say bundle 4?
Bundle 3,
3.
tab 24, page 333. And this really sets out in written form the submissions that I've already been making in relation to the deficiencies in the SBLC as originally provided and indeed as subsequently provided. Paragraph 55, as appears from Mr. Zier's first witness statement of paragraph 16, the defendant caused a standby letter of credit to be issued dated the 3rd of June 2015.
Now what are you reading from?
Paragraph 55 on page 333.
55, okay.
Yes. As appears from Mr. Zier's first witness statement, paragraph 16, the defendant caused standby letter of credit to be issued dated the 3rd of June 2015. A copy of that SBLC is comprised within the exhibit. Several points arise, namely, that the applicant for the SBLC was not the defendant but was interviewed. The SBLC was not issued in favour of the claimant. The beneficiary was identified as Edwards Moon. Even though the SBLC was transferable, it was not issued in the form which the defendant had acknowledged was in proper form, or was to be the proper form. And for his acknowledgement, see paragraph 10 of Mr. Zier's first witness statement. More importantly, the SBLC was substantively defective, not in terms acceptable to the claimant's bankers. And then I refer to the email which I've already taken you to, and the amendments which were made or requested. Requested not made, because as one goes on to see in paragraph 56 at the foot of that page, the defendant has acknowledged amendments were requested. See Mr. Zier's first witness statement of paragraph 18. The defendant does not say that those amendments were either accepted or incorporated in a revised standby letter of credit. And if that were the defendant appellant's position, then one would have expected to see evidence in that regard. Over the page, paragraph 57, even if that were done, and in the House of it complaint it wasn't, even if that were done, it doesn't help the defendant. As the defendant has acknowledged, see paragraph 21 of his first written statement, Mashreq Bank was acting on his instructions, and then the relevant passage is summarised. I sent instructions to Mashreq Bank to immediately transfer the instruments to the bank account of the claimant. As the defendant has further acknowledged, see paragraph 22 of his first written statement, Mashreq Bank said it could not follow those instructions because of compliance issues. Then there's a statement which my learned friend has already referred to, namely that a standby letter of credit has the status of movement to cash. On the present facts, it is clear that payment is agreed by way of an irrevocable standby letter of credit was never made, i.e. the cash equivalent was never received by the claimant or the claimant's bankers. Then paragraph 59 refers to the witness statement of Mr. Akbar, who made his witness statement on behalf of the claimant. For the court's reference, that is to be found in bundle 3 at tab 20. This was the information which was forthcoming in the course of the Dubai Court's judgment. It can be seen, this is what Mr. Akbar says at paragraph 17 of that witness statement, it can be seen from the judgments that a representative of Mashreq Bank submitted a statement in the criminal proceedings to the effect that the defendant's company, Interpol, was under investigation by Interpol, and that Interpol has issued a warrant in relation to the defendant himself. That must be the real reason that the SBLC was not able to be transferred to the claimant's account. The defendant, Mr. Zier, commented on that paragraph in a subsequent witness statement, namely his third witness statement, at paragraph 16G. And again, for the court's reference, that is to be found in Bundle 2, tab 11, page 176. Bundle 2, tab 11, page 176. And again, I think that what it says is sufficiently clear from the skeleton argument, so I won't take the tribunal for reasons of time to that particular.
Which paragraph of 176?
It's paragraph 16G.
Okay.
He doesn't dispute any of the substance of what Mr. Al-Akrawi had said, he merely contends that the claimant agrees that it was not on account of my fault that the SPLC was not credited into its account, but on account of other reasons. Commenting on that, or making submissions in relation to that, we said paragraph 61, the defendant's attempt to absolve himself from fault and responsibility is, in our submission, quite unsustainable. The defendant was the purchaser of the properties under each of the 72 contracts. The defendant was obliged to pay the total purchase price under those contracts in accordance with their terms. And again, the learned friend has acknowledged, as indeed he must during the course of argument today, that was indeed his client's obligation. He said his client's obligation was to pay the money. And the DIFCI's obligation was, to use the learned friend's own phraseology, to transfer once payment had been made. And it's quite clear that the defendant did not make payment. Picking up at paragraph 62, at the foot of page 334, the contracts created a straightforward obligation to pay and a commonplace means to do so. If the defendant has so arranged his affairs with those of legal persons under his control, i.e. Internode, so they came under Interpol investigation, or were reasonably believed to be under such investigation by a bank acting to his order as an agent of the company under his control, with the result that the bank was constrained not to follow his instructions in fulfilment of its own compliance regulations, the defendant cannot, in our submission, claim that the resultant failure to pay was, quote, not my fault. The position is that payment under the SPLC was prohibited by law, or I suppose that the only other alternative would be if Mashreq Bank had got the wrong end of the stick, then the defendant's proper recourse would have been against the bank, a step he was not taking. So leaving that possibility aside, the situation is that the defendant has not provided cash equivalent in satisfaction of the total purchase price. And we say that it's an affront, really, to contend that such a failure is not a failure for the purposes of Clause 6 of the contract, nor fundamental non-performance within the scope of the DIFC contract law, nor an infringement of the relevant provisions, namely Articles 267 to 268 and 271 to 272 of the UAE Civil Code. Now, again, those are in the bundle, and I can take you to them if you wish to, but really it's a case of matching those provisions against the references here. Clearly, whether you look at it under Clause 6, whether you look at it under the DIFC law, or whether you look at it under the UAE law, this was a failure which was a fundamental non-performance, entitling termination.
Okay, I'm going to stop you there because I think this is the time for a break.
Indeed, yes.
Yeah, I'm going to set you both some homework. First of all, Mr. can you, I don't want you to tell me now, tell me after lunch. Can you explain, in the measures taken by your client to create another mode of payment via the SPLCs, why was it not possible for your client, using his own company as the beneficiary of the standby letter of credit, to actually encash it himself, take cash, buy a manager's check, and then complete the transaction? As I said, that's the question for you. Don't answer me now. Right? For Mr. Patrick Joyce, I wanted to ask, pick up on this point of how you arrived at this conclusion that we should be applying federal law, I think you're starting to point me to the relevant portion. But let me explain to you, first of all, why I need to be brought back to that, because the starting point for DIFC courts normally is that we don't look at federal laws in civil and commercial matters, and that's by a combination of the, well, basically the federal law itself, Federal Law Number 8, 2004, Article 3, which says that the free zones are subject to all federal laws with the exception of federal civil and commercial laws. And then I think you have referred to it, which is DIFC Law Number 3 of 2004, which is the application of civil and commercial laws in the DIFC. I think you may have referred to that, you're starting to. Are you saying that DIFC law itself allows parties to reapply what has already been disapplied, namely federal civil and commercial laws, right? And if so, then, I mean, I think I saw that argument in your submission, but then I didn't have time to pin it down. I could not find the discussion of Article 272 of the the UAE Civil Code, which you had just started to refer to. Maybe we'll look at it after lunch. Because as I understand Article 272, before you terminate a contract, you have to give notice. So what we're looking for here is where has your client given notice to the buyer that here is a condition which is of the essence, and he's got to perform that particular condition by a certain date, after which you will exercise. So you need that drop dead notice.
Yeah. No, I can actually answer that very quickly. Because clause 17 is the clause which establishes in our submission that UAE law as opposed to DIFC law applies, because our case is that, yes, of course, the appropriate court, the appropriate jurisdiction is the DIFC courts, because the DIFCI is a DIFC entity. So that establishes jurisdiction. But then clients may agree to apply different laws, and they can agree to apply the federal laws of the Emirate and the laws of the Emirate of Dubai, which is indeed what one finds expressly to have been agreed in clause 17 of the contract. And the court will find that in Bundle 1, tab 4, page 29.
But for the purpose of resisting the appeal, you don't even need to go to here. Just do so on the basis of DIFC law.
Absolutely, and that's why we put it in the alternative, because both roads lead to Rome. Yes, it's a distinction.
But then in DIFC law, you also have to give the notice as well.
But then one looks at the clear express provision in clause 6, which is the requirement to pay.
Yes. All contracts have a requirement to pay. All contracts have a requirement to pay on a certain date.
Yes.
The question is, do you need something else beyond that?
Well, the learned friend has taken the court through the chronology, and in my submission it is absolutely clear that on the approach to the 7th of June, people said that the date that was then fixed was not appropriate.
Yes.
So there was an express agreement in relation to the 18th.
The completion date, which was extended.
And it was absolutely clear.
Yes.
So that, in effect, that continuous exchange was notice, and then between the 18th of June, there was recognition that this had not been paid. Time continued to be of the essence.
No, but in order for time to continue to be of the essence, it had to be of the essence in the first place. So you have to come back and tell me from what you derive the fact that a particular date was of the essence, whether it was the original date of, what was it, something early June, and then the later date that it was agreed to change it to. And
We come back to clause 6,
Yeah.
which of course is the one thing the judge didn't decide. But that's where we come back
we
to.
will look at clause 6.
And I think the final sort of piece of the jigsaw is that we've referred to the Akbar capital case and what Sir Anthony Coleman said at paragraph 72 in relation to time of the essence.
Okay, we'll have a look at that after lunch then.
Tab 6 of bundle 1.
Well, the bundle is a bit heavy to carry to the lunch venue, so yeah, we'll look at it after lunch. Yeah? So just to ask you to help us with that. Huh? Okay, thank you.
Guys.
On.
Yeah, let's go and check this. Oh, an hour. We'll be back at 2. Yeah. Yes. Yeah. Do they lock? Do they lock the court? They don't. So in other words, we can grab a sandwich and then still have access. Yeah, it is. Yeah.
But that is very easy in an answer because the experience itself says that only for assumption to separate two things you can do. And since we are on the owners, we cannot do that. That was one who was very